Okay. Good morning, colleagues. My name is Charles Ndugu, the president of SACAP. This is our webinar today for the code of conduct. I'm not going to be too long. I'm just here to welcome everybody, the panelists and the RPs, all those that are actually joining us in different platforms of social media. Code of conduct is very important part of our practice. And at SACAP, we've noticed that there is a lack of understanding in the issue of code of conduct. How is it applicable? How RPs are supposed to be, practicing in accordance with the code of conduct? And we've had some few cases, that could have been avoided. But by doing this, we are trying to actually bring it to the RPs and to sort of create an awareness and knowledge around the issue of code of conduct. And when I spoke to the registrar and the IT, they will be actually engaging the RPs with regard to this. We might produce a, a small booklet, which is a code of conduct in a nutshell. So to try and assist our RPs as much as we possible can. It's not a lot of issues that are there, but we always realize that RPs get caught in a very small little issues that they could have avoided. For an example, not getting into an agreement between yourself and your client. Most of the cases are actually centered around there, and of course, and other issues that are always problematic. But in so doing today, we are trying to uh, try and make an awareness to all architectural practitioners around the issue of code of conduct, and it's going to be an ongoing, sort of knowledge-based interaction between SACAP and the RPs and the architectural practitioner. It is important to all categories of architectural practitioners. So, in those words, I would like to welcome all of you and wish you the best in 2021. We've had a very tough 2020 due to COVID-19. COVID-19 is still with us even today. We're still battling with the COVID-19. We've heard the issues of the vaccine, and we hope that the medical practitioners and scientists will actually solve those problems so that we can have some hope. In those words, I want to welcome everybody who has joined today. And I see the number at the moment. We are around 266, and want to thank all of you, those that have participated or are participating. So I'd like to hand over to the registrar. Thank you very much.
Good morning. I've just been advised that I was on mute. Let me apologize for that glitch. Basically, let me thank the President for taking time to welcome the profession for today's webinar. So our webinar today is really to deal with the issue of the code of conduct. Now, recently, SACAP has published a new code of conduct accompanied by the rules of inquiry. So there was a wide consultation, and we've received a lot of comments that were considered by the investigating committee as well as the council. So we deem it appropriate that we also run workshop webinars so that we increase the knowledge and understanding of the code of conduct in the entire profession. But we thought that today we want to assist all those professionals who have been through SACAP processes, those who have been the complaints have been lodged against them by members of the public, so that at least we increase their knowledge and understanding of the code of conduct. So let me share then the screen with you as we run through this this webinar. Can you see the screen there?
Yes.
Yes.
Yeah, we can see the screen.
Right. I seem to have lost the presentation from my side. All right. So basically, my presentation is quite short. I'm going to introduce the matter and then speak to the objectives of the webinar, and then from there conclude. And thereafter, I'm going to hand over to our legal and compliance officers to run through each and every section of the code of conduct. And then there's going to be a lot of interaction between the profession as well as the legal and compliance officers to explain any issues that the attendees might want to clarify. So the first thing I want to outline is that SACAP is mandated by Section 27 of the Act to draw up a code of conduct. And SACAP is required to consult with the entire profession when they draw a code of conduct. So that process has occurred. We now have a code of conduct after following a wide consultation. Now we have a code of conduct which is now being gazetted. Now, the Act also mandates SACAP to administer the code of conduct. Now, for us to be able to administer the code of conduct, we require registered professionals to understand and know the code of conduct. And if the profession know and understand the code of conduct, it becomes very easy for SACAP to administer it. And we've noted through our disciplinary processes, we receive approximately a year about 160 complaints. Now, if you assess all those complaints, you'll note that some of the things that have been raised by members of the public and by our clients could have been avoided if there was a proper understanding of the code of conduct. In fact, some registered professionals have come and said, look, we've never seen a code of conduct before. We've never seen the Act before. It's for the first time that so it's very difficult for SACAP to expect professionals then to comply with a code of conduct that they don't know. And Section 27 subsection 3 of the Act provides that all RPs must comply with the code of conduct, and failure to do so constitutes improper conduct. Now, you'll not be able to comply with a code of conduct that you don't know. So it is important that we roll out this webinar so that we increase understanding and knowledge of the code of conduct. Now, we believe that the training on the code of conduct presents an opportunity to the profession and to RPs to expand your knowledge and understanding of the rules. And then that will itself then improve compliance with the code of conduct and reduce the number of complaints that we receive. Now, those RPs who are competent on the code of conduct will be able to handle clients professionally at all times. And in that way, we're able to build confidence in the profession. And it will also improve the level of trust and confidence in the profession. So we believe that the understanding of the code of conduct by professionals will foster an environment of trust, ethical behavior, integrity, and excellence in the agriculture profession. We believe that the training of the code of conduct provide a supporting framework for RPs to resist any pressure to act inappropriately and to make acceptable decisions that are in line with the code of conduct when dealing with clients. A good understanding of the code of conduct will assist RPs to distinguish between what is wrong and right, and also encourage behavior. Now, if you don't know the code of conduct, you will not be able to know what is expected from you, and you won't even be able to draw a conduct which is wrong and a conduct that is right. So that's why we say that it is critical for RPs to understand the code of conduct so that they are able to uphold it when they are dealing. SACAP believes that the act of doing business are becoming more critical for any profession. So it's important that when you are doing business, ethics are very, very so, and that's why we believe that training on the code of conduct is very important. And we want the entire profession to embrace the code of conduct when conducting business. In that way, very much. I'm now going to hand over for the first presentation, which is going to start outlining the legislation before it goes to the code of conduct. Thank you very much for being here, and thank you very much.
Good morning, everyone. My name is Khaugelo. I will be taking over from the registrar. I'll be taking you through the legislative before we go to our new amended code of conduct. Selina will share the code of conduct for us. We'll share the presentation, sorry, for us.
Okay, Khaugelo, I'm handing over.
Yes, yes. I don't know if you can hear me. I am speaking. Selina is now sharing the screen, and I'm taking over from the registrar. Thank you, registrar. Okay, we will go to the second slide, the content. What I will be taking you through is I'll be taking you through the built environment profession, and I'll also be taking you through the SACAP Council compulsion and SACAP Council mandate, license to practice. And then we're also going to look at why did we have to amend the code of conduct. And then we'll also, after that, we'll look at the rules in our new code of conduct. The legal team will take you through all of the rules, the new rules in the code of conduct. And then after that, we'll talk about the cancellation of registration, and we'll also look at candidates. With SACAP, with SACAP as a council compulsion is that it's a statutory body, and in the legal fraternity, they like saying that we are a creature of statute. So as SACAP, we exist because of an act, and the act is the Architectural Profession Act number 44 of 2000. And the council is composed of 7 registered persons who represent 4 categories of registration. With regard to 4 categories of registration, we have professional architects, we have professional senior technologists, we have a technologist, and then we also have draftspersons. So with in our council as SACAP, all these categories are represented. So you must just rest assured knowing that your category, whether you are a draftsperson or whether you are a professional architect, your category is represented in the council. And further, the minister is empowered to appoint the council members. So the council members were appointed by the Minister of Public Works. And then looking at our vision, mission, and values, our vision is to transform the architectural leaders, serving society in a sustainable built environment. And our mission as a council, as SACAP, is that SACAP is inclusive and is transparent. So whatever we do is inclusive and is transparent. And further, an architectural profession recognized as a global leader in the built environment. So that's one of our mission. And our other mission is that we have a clear understanding of our mandate amongst other regulators and stakeholders towards a comprehensive conclusive delivery. So that's what we exist for. That is our mission as SACAP. And obviously, as an organization, we have values. So our values is that it's a responsibility. Whatever we do, we are responsible for it. And then we are being accountable for the decisions that we make and our actions as an organization. And further is excellence. That's why we have the code of conduct today, because architectural profession have a higher standard. So you look at, you see when we discuss the code of conduct that high standard is one of our values. It's going to be highlighted in the code of conduct. And another thing is the integrity. Integrity is one of our values as an organization, because we value ethical behavior, honesty and trustworthy. So that's why we have a code of conduct. Our integrity will also be rubber stamped in our code of conduct. It will be discussed later. And then transparency and then cohesiveness. This will also be rubber stamped in the code of conduct. Now looking at SACAP as a council, our mandate. SACAP's mandate is to register professional in the 4 categories of registration. I've already mentioned the 4 categories of registration that we have as an organization. It's our mandate to register these categories, and then further also to register our candidates. And then another thing is our mandate is to accredit architectural learning institutes and consult with Council for Higher Education in relation to education in architecture. That is one of our mandates. And further is to determine registration and application fee. And then another mandate of ours is to keep the register of a registered person and further to administer the affairs of the organization as SACAP. And also our mandate is to protect the public, hence the code of conduct. So we have the code of conduct that we expect our registered person to adhere to. And then when they adhere to, that is how we also fulfill our mandate of protecting the public. And then another step, another mandate of ours is to take any step it considered for the improvement of the standard of service rendered by registered persons, and further to protect the built environment against unsound architectural practices. So that's why we have the code of conduct. By the code of conduct, and then you as a registered person adhering to the code of conduct, you are protecting the built environment against unsound practice. And then further, we recognize voluntary association, we determine identification of work, and then we formulate professional fees guideline, and we make rules with regard to any that is permitted by the Act. As I've stated before, that we're a creature of statute. We exist because of a statute, which is Act 44 of 2000. And then also looking at our mandate, on section 17 of the Act 44 of 2000, is stipulated that that as an organization, we may establish any committee included to this committee, it assists with performing our mandate. So this is why with regard to our committees, we look at the investigation committee. I believe that most of you knows about the investigation committee, and then it also be explained as the register has also explained that when we receive a complaint, we investigate it and it goes to the investigation committee. That is the function of the committee that section 17 mandate us to formulate or to establish. And then there are other committees that the council may establish, and then those are the education committee, we have a fee committee, we have IDOW committee. And further, when we look at the license to practice, with the license to practice, as a person who's registered, or as a person who's not registered rather, you may not practice architecture in whatever way. As long as you're not registered with the council, you may not practice architecture. So I'll look at section 18. And when I'm referring to sections, just bear with me, I'm referring to our acts, the Act 44 of 2000, Architectural Profession Act 44 of 2000. Section 18, subsection 2 of the same act, it says a person may not practice in any of the category unless he or she is registered in that category. Looking at the categories, as I've stated before, we have a professional architect, we have a senior technologist, we have a technologist, and we have a draftsperson. So if you are not registered in any of those categories, according to section 18, subsection 2, you may not practice architecture. And then it goes to section 41, subsection 1 of the same act. It says that whoever contravenes this act, whoever practice architecture without being registered, he is guilty of an offense. So if you practice architecture without you being registered, you are guilty of a criminal offense. So that's where the prosecution will come in. That's where the police will come in. So if you are not registered, please do not practice architecture in any way. So section 26, subsection 3, subsection B and D, it says a person who's not registered in the act may not pass himself or herself as a registered person. So if you are not registered as any of the categories that I've mentioned, you may not make people to believe that you are registered in any of these categories. So you may not, if you, let me give an example, that if perhaps you give the impression to other people that you are registered, so you are also guilty of an offense, because now you are passing yourself as a person who's registered, where else you are not. So you will also be charged in terms of section 41, subsection 1 of the Act. So you will be charged with a criminal offense, because now you are passing yourself as a person who's registered while you're not. So what I also want to emphasize is, if perhaps you registered in 2015, and then you paid annual fees for 2015, and you did not pay annual fees for 2016, you are considered as a person who's not registered. Just because you have a registration number doesn't mean that you are registered. You must pay your annual fees in order to be considered as a registered person. So with regard to section 26, subsection 3, subsection C, a person who's not registered in terms of the Act may not even use the title of a person who's registered. So if you are not registered, you may not go around telling people that you're an architect, because you are not supposed to be going around using the title that is referred to a person who's registered. So even if you're not drawing the plans, you may not tell people that you are registered, or you may not tell people that you're an architect, just because you once had the title of a professional architect, and then now you are no longer, like, now you didn't pay your annual fees, you're considered as an unregistered person. And then in that way, you may not go around using the title of a person who's registered. So you may not go around using the title of a professional architect, a senior technologist, or a technologist, or a draftsperson. So only if you are registered, you may use those titles. So just to emphasize, the titles, these titles are only reserved for registered persons only. So if you're not a registered person, you may not use these titles. So now we are going to the most exciting part of the presentation. Okay, no, we are not there yet, it's the next slide. But with the rules of professional conduct, is that I believe that the advocate has already emphasized on this, is that the code of conduct, we established it because of section 27 of the Act. And further, registered persons are subject to a disciplinary provision of the council. So this means that if you don't adhere to the code of conduct, then it means you will be subjected to the disciplinary supervision of the SACAP council, of the council. And then, so that's why we are having this presentation, to make sure that you understand the code of conduct. And then if you understand it, it's easier for you to adhere to it. So with regard to the next one, this is the most exciting slides in all this presentation, in the whole presentation, I must say. So now we are here because we have we have amended the code of conduct. So now the question is, what was wrong with the old code of conduct? Why are we amending the code of conduct? So the code of conduct, we're amending it because we want to close the gap. We are addressing the new legislations. So there are legislations every year, every month that we need to close up. We need to adhere to as an organization. And then as you can recall, the code of conduct that we've been using, it was gazetted in 2009 already. So that's a long time ago. It's over 10 years. So it's almost 10 years. Yeah, okay, yeah, it's almost 10 years. So that's why we had to have a new code of conduct. I would like to take you back to our mandate, our values, sorry. We want to keep up, they say you keep up with the trends. So what we're trying to do is we're trying to address the gaps, because most of the complaints that we've been receiving is because we believe that there are other gaps that we can close, that we can address in the code of conduct, that the registered members can adhere to, then we won't have those complaints on our desk. So we are trying to close the gap. And because of the evolving architectural profession is evolving, everyone is going digital now. So that's why we saw the need that this code of conduct need to be amended to be in line with what is happening, what is current now. So we don't use an old code of conduct that was gazetted in 2009. So now we're closing the gap, addressing the complaints that we're receiving. So there are complaints that we've been receiving that we believe that if this certain clause can be in the code of conduct, registered members will avoid receiving complaints, will avoid having complaints against their names. So that's why we are amending the code of conduct. We are excited as an organization that we are finally amending the code of conduct, and then we are excited that will be taking you through the new code of conduct, and we believe that you will receive it well, and then you will adhere to it, because it's a clearer code of conduct. I believe it's going to be easier to adhere to. So what I would do is we'll go to the rules of professional conduct. It's a yes. Tabani and John Zella will be taking us through the rules of professional conduct. I'll hand over to Tabani.
So much, Jorge. Greetings to the president, greetings to our registrar, Advocate Dr. Fuduli, and greetings to all the participants. I'm sorry if there's other people that are supposed to mention specifically, but I'd just like to greet you, and I'd just like to say it's a pleasure to be able to present this code of conduct. As the registrar said, there has been a lot of work being put into it and a lot of consultation process being put into this code of conduct. Just to take off from where my colleague left over about the changing of the code of conduct, there's a famous quote that I'm reminded of Winston Churchill, that to improve is to change, and therefore to be perfect is to change often. So as a SACEP, we are looking to, even though we may not reach perfection, but it's something that we strive for, and in doing that, we constantly have to adjust and constantly have to innovate in the way we do things. So I'm just gonna start off where my colleague left off. So the rules of professional conduct. Rules prescribes the ethical principles and rules for conduct that all RPs are expected to uphold and be measured against. Rules sets out values, principles, and standards that RPs have to adhere to when dealing with the public. SACEP takes great interest in the professional conduct and integrity of the RPs. So the rules are divided as you can see. Rule 1 relates to integrity. Rule 2 relates to competency. Rule 3 represents honest promotion of services. Rule 4, administrative functions. Rule 5 is establishment of the architectural practice. Rule 6 is the public interest and environmental. Rule 7 is the regulation of foreign architectural professionals. And then Rule 8 is the disciplinary procedures. I'm going to take you through rule 1, and then my colleagues will move on further. But to move on to the next slide, the application. So who does this rule applies to? These rules applies to, sorry. The code of conduct applies to person in whatever these rules apply. Hello. Okay, let me just carry on. So as I was saying, that these rules apply to specifically to persons registered in terms of the act, whether it be candidates or professionals, and not people that fall out of it. So the second part is what will happen should these rules not be adhered to. If an RP fails to, which is deemed by the council to constitute improper conduct, it shall proceed with disciplinary action against the RP. If Selena can go to the next slide. Application, the effective dates of the new amended codes. In the event of any improper conduct committed prior to the effective date of this code of conduct, the council shall have authority to charge a registered person under the code of conduct applicable at the time of the incident. So as we all know, it's actually a constitutional principle that you can't be charged retrospectively. You can only be charged in terms of rules that are on laws that are in place at the time of the committing of the offense. So if you committed an offense, let's say in 2019 or 2020, then the old code of conduct shall take in effect. And then if you've charged, if you've committed an offense from now going forward, then this code of conduct shall take in place as soon as this has been published. So rule 1, integrity. Rule 1.1, a registered person shall take into consideration the standards of honesty and integrity that underpins this code of conduct when performing architectural work. A registered person shall at all times act with honesty and integrity and avoid any action or situation which may be detrimental to the esteem and dignity of the profession or the conduct which brings the profession into disrepute. Rule 1.3, a registered person shall not make any statement which is contrary to their professional opinion or which they know or ought to have known to be misleading, unfair, or others, or discreditable to the profession. So you can move on. So basically, you would probably find that a lot of these rules, like they similar to each other, but one thing that I've noted is that when we do charge people, we don't charge people twice for the same offense. So even though the rules may be similar, you won't be charged twice for the same offense that you have done. So rule 1.4, a registered person shall not knowingly undertake work in the circumstances or under conditions or terms that would compromise their ability to carry out their responsibilities and fulfill their commitments to their clients. A registered person shall not misrepresent or knowingly permit misrepresentation of their own or any other person's academic or professional qualification or competency, nor exaggerate their degree of responsibility in architectural work. Rule 1.6, a registered person shall not negligently issue any certificates in connection with any building project on which they are professionally engaged with. So as you can see, that a lot of these things are in line with the principle that we have in rule 1, which is integrity, honesty, those types of principles that we want our registered persons to uphold themselves to. So rule 1.7, a registered person shall notify council without delay if they become subject to any disqualification as contemplated in section 19.3 of the Act, as failure to do so may be deemed improper conduct. A registered person shall not receive directly or indirectly any commission or remuneration for recommending a particular product, supplier, service provider, or contractor to a client for work of a building project without informing the client in writing. Rule 1.9, a registered person shall declare to any potential client any business interest, including any business of property developers, property auctioneers, estate agents, building contractors, subcontractors, suppliers in or to the building industry, or the design and build practice, interest, if not declared, could raise or may be likely to raise doubts in their integrity and impartially independent. So those rules would raise a lot of questions, and we will have a Q&A session after this to attend to clarify that if there's any questions. So rule 1.10, a registered person shall remain bound by these rules even after the occurrence of a non-payment and of the annual registration fees and after the suspension of the registration in terms of section 21A3 of the Act due to failure to pay subscribed annual registration fees. A registered person shall not practice architecture during the period in which their registration has been suspended in terms of section 21A3 of the Act due to failure to pay prescribed annual registration fees. Rule 1.12, a registered person section 32(3)(3 of the Act due to being found guilty of improper conduct by a disciplinary tribunal. So like, as my colleague was saying, is that there's a lot of people that have been trying to get out of like gaps as far as that if they haven't paid annual fees, if they suspended, and they try to kind of move away from our jurisdiction. But now we've put in clauses in order to deal with that or cure that. Rule 1.13, a registered person shall not practice architecture after the registration has been cancelled in terms of section 32(3)(a)(4 of the Act due to being found guilty of improper conduct by disciplinary tribunal. A registered person shall not practice architecture after the registration has been cancelled in terms of section 21A of the Act. 1.15, a registered person shall treat clients and fellow registered person with due dignity, respect, and courtesy. Rule 1.16, a registered person shall, in giving advice, exercise impartiality and independent professional judgment. And rule 1.17, a registered person shall not engage in the act of dishonesty, corruption, or bribery. So yeah, as I was saying, that's a lot of these rules, they're dealing with almost like if you were a director or something, like your fiduciary duties, your duties to be honest, your duties to be professional, and uphold all those things that we expect from registered persons. I'd like to pass over to my colleague, Besi Shope, who will be taking over the next room. Thank you so much.
Good day, everyone. I will be taking you through Rule 2 to Rule 6 of the Code of Professional Conduct. Thank you for the time. Rule 2 deals with competency. So this is what Rule 2.1. A registered professional shall discharge their duties to the employer, client, agent, associate, and the public with due skill, diligence, and competence. Shall, where reasonable, make appropriate arrangements for the fulfillment of professional obligations in the event of incapacity and or absence from work and or inability to perform work. A registered person shall only undertake architectural work which is identified for the category of registration in which they are registered in terms of section 18 of the Act and in accordance with the registration categories in force. Rule 2.4, a registered person shall, where work is carried out by a registered candidate under their supervision, take responsibility for ensuring that such candidate is appropriately registered, competent to perform tasks, and is adequately supervised. 2.5, a registered person shall ensure that registered candidates do not have any financial interest in any architectural practice or a multidisciplinary practice that performs architectural work other than in respect of bona fide remuneration for their services. 2.6, a registered candidate must perform work under the direction, control, and/or continual supervision of a registered professional entitled to perform such work and who must assume responsibility for any such work. 2.7 says a registered person shall regularly undertake continuing professional development activities in order to keep up to date with developments in the practice of architecture and to enhance and maintain their professional expertise and competence. Okay. Quickly, sorry. Thank you. Rule 3, promotion of services. Rule 3.1 states, a registered person may only communicate and promote themselves and their professional services in honesty, describing both in a manner that is related only to the work of the professional categories of registration represented in the practice. 3.2, shall credit the architectural work done during a period as a principal or employee of another architectural practice and shall make clear reference and description to such practice. 3.3, shall ensure that the name under which an architectural practice operates is not misleading or capable of being confused with that of another practice. And 3.4, shall not use the architectural work prepared by another registered professional without written authority from the originating registered professional. And then we have Rule 4, which is administrative functions. Rule 4.1 states as follows: a registered person shall ensure that before they undertake any professional work, they have entered into a written agreement with the client and must inter alia. 4.2, shall not change the terms of appointment, including the scope of work, without the written instruction or approval from their client. 4.3, shall ensure that at the completion of each milestone, the client signs off where the scope of work involves more than one stage. Rule 4.4 states, shall sign or otherwise identify as having been in any building plan or document of which their architectural practice is bona fide author, or where such building plan or document has been prepared under their direct supervision. 4.5, shall sign or otherwise identify as having been issued by them any building plan or document of which their architectural practice is the bona fide author, or where such building plan or document has been prepared under their direct supervision. 4.6, shall attend to all corrections requested by the local authority on the drawings prepared by them within a reasonable time. 4.7, they shall issue certificates that are based on the correct facts on site. We are still on Rule 4. We are at Rule 4.8. A registered person shall take adequate and appropriate professional indemnity insurance to cover all architectural works, shall, when requested by SACA, provide evidence of professional indemnity insurance within a specified time. 4.10, shall, within 30 days of change of personal details, such as email address, physical address, and postal addresses, telephone and numbers of the practice, inform counsel in writing thereof and ensure that such details are kept updated. This is 4.11. Registered person shall keep all plans, records, certificates, and or drawings commencing from the start of work and up to the period of 5 years from the date of final completion. 4.12, they shall not disclose confidential information obtained from clients except written permission and in compliance with the Protection of Personal Information Act. 4.13, shall carry out professional work within the agreed time or within a reasonable time. 4.14, they shall keep their clients informed in writing about the progress of the work on their behalf within any issue which may significantly affect its quality or cost, and any other considerations which may substantially affect the project. 4.15, they shall take responsibility for work carried out by their subordinates, including persons that are registered as candidates. We are moving to Rule 5 of the Code of Professional Conduct. Rule 5.1 states as follows, Rule 5 deals with the establishment of an architectural practice. Rule 5.1, any registered principal who practices architecture in any form shall, within 30 days of the establishment of the practice, register it with the council, giving full details of the practice name, address from which the practice is conducted, the type of practice, supported with corresponding registration details and names of partners, shareholders, directors, and employees undertaking architectural work in the practice. 5.2, the council shall be informed in writing of any changes in the name type, address, composition of a practice, and its termination within 30 days of the relevant occurrence. 5.3, the registered principals of a practice shall display their registration certificates in a prominent place in their physical or their virtual workplace. 5.4, registered professionals and multidisciplinary principals shall not describe their name or name their practices as architectural practices unless the majority shareholding or voting powers, are held We are still at Rule 5 of the Code of Professional Conduct. Rule 5.5, in any multidisciplinary professional firm which also practices architecture, a registered principal shall be responsible for the architectural work. All provisions under the Code of Conduct shall apply to all multidisciplinary practices. Rule 5.6, a registered person shall not accept with the permission of the council and under such conditions as the council may prescribe, enter into any professional relationship or association for purposes of performing architectural work with any person who is not a registered person or a registered profession of a closely allied profession. Permission will not be granted if the person concerned, sorry, this is not complete. Rule 5.7, every office established for the purposes of conducting an architectural practice shall be under the continuous, direct, and personal supervision of a registered professional who shall continually review and oversee the work of the practice. The registered professional shall be in attendance for a period of at least 8 hours per week. The registered professional shall prominently display office hours and contact details on electronic platforms or place of operation. We are still at Rule 5.8. The type of practice shall be determined by the registration category of a registered principal. Actively engaged in the practice. Rule 5.9, the practice shall not use a type which portrays itself by the name or to be in a higher category than that of the registered principals who own the practice. Rule 5.10, a person registered in the category of candidate shall not establish an architectural practice, act as a principal or a shareholder in an architectural practice. Rule 6, public interest and environmental protection. Registered persons shall, in the performance of their duties, take all reasonable measures to the best of their knowledge, expertise, to minimize any adverse impact on the of individuals and communities that could be affected by their work. 6.3, comply with the National Building Regulations and Standards Act 103 of 1977. Town planning schemes, national heritage resources, and any other built environment laws and any other applicable law governing the works. 6.4, where appropriate, advise how to best conserve and enhance the quality of the environment and its natural resources. When providing architectural, this is Rule 6.5, when providing professional advice to a client or employer, and such is not accepted, inform them in writing of any consequences which may be detrimental to their health, safety, or interests of the public. Thank you. My colleague, Mr. Makakavule, will be taking over from Rule 0.7. Thank you very much.
Thank you, Bessie. Hi, everyone. My name is Ntangane Zeni Makakavule. I'm sure most of you are aware of the name, and today you put together the face and the name. Yes, I'm a legal compliance officer at SECAP. I will be taking you through the code of conduct, the remaining part of the code of conduct. And yes, if it is your first time getting to see what is on the code of conduct, it might seem like it's a lot that you have to make sure of. It's a lot that you must take in. It's a lot that you must be aware of. But with time, it will be much easier. And then as SECAP, as my colleagues have already stated, we're trying to protect the profession. That is our mandate, to protect the profession. And by doing so, we also protect our architectural professionals and also protect the public. So most of the times we get questions as to say, how is SECAP protecting me as a registered professional? And what does SECAP do for me as a registered professional? They will be going on to say, no, we are, SECAP only takes care of the public, and they do not take care of ourselves as registered professionals who are paying registration fees, annual fees on an annual basis. So one of the examples what SACAP does to protect the professionals is that by protecting the profession, we make sure that only registered professionals are allowed to practice. So we are preserving the architectural work for only registered professionals. So that is where it's easier to see and note that SACAP is protecting the professionals' work by making sure that only professionals who are registered with SACAP perform architectural work. We also, another example would be that one of my colleagues have stated in terms of rule 4, where that you must make sure that before you enter into any architectural work with public, you enter into a written agreement. So this protects you and also protects the member of the public, because when we make our investigations, we're aware of the fact that sometimes it's not the architect who is at fault. Maybe it was a matter of communication issues. Maybe it was a matter of the mandate was not clear. But if you have your terms of appointment in writing, if you know what you are going to be doing, and if you know, and if your client is aware of what you are going to be doing, when the client comes to SECAP and lays a complaint and says, no, professional B did not do this and that, and this was my agreement with him. And then when we look at your terms of appointment in writing, we don't have to go to who said this and who said that. We look at the terms of appointment in writing. You have stated that you are going to draw the plans, get them approved, and thereafter submit them to your client. So that helps you in the event that maybe your appointment was not clear to your client, because I mean it happens a lot of times that the members of the public are not aware of what is the scope of architectural work, because from stage 1 to stage 4.1, it's just approval of plans, and then there is stage 4.2 to stage 6, wherein the architect can be a principal agent. If that is not clear on your terms of appointment in writing, you are left with a client who will be saying, no, he was supposed to be on site. But did you say that you're going to be on site in your agreement? If your agreement says it's from stage 4.1, it's stage from 1 to 4.1, then that's it. You are paid for that. So we don't want to encourage he said, she said. So when you have your terms of appointment in writing, it's clear. We don't go anywhere further. We just look at what you have agreed upon, and then that's how we as SACAP also protect you from the members of the public, while we protect the profession and also protecting the members of the public. So we are going to go to rule 7. I'm trying to be as slow as possible, so because it can be too much at times. So we'll try to make sure that you get to understand as easy as possible how the rules have been amended and how the rules must be administered by us, and how you should adhere to the rules on your day-to-day work, day-to-day practices in your offices. So Rule 7 is the rules of professional conduct. It deals with foreign architectural professionals. So Rule 7.1 states that all foreign architectural persons must comply with the Architectural Profession Act of 2000 to practice architecture lawfully in South Africa. So this means that all foreign architectural professionals or firms who are going to be doing work in South Africa, they must adhere to South African law, and they must adhere to the Act 44 of 2000 to practice architecture lawfully. So it means that they must be registered, and a person who would be a registered person, a foreign professional must be registered so that he can be able to submit plans to the local municipality or council. It says here 7.2, no foreign architectural person shall be authorized to practice architecture in South Africa unless they have applied and have been granted registration by the council for the duration of the specific contract. So it means that if there is a contract, that must be, if there's a project that they're doing, they must apply to SECAP. They must be given permission to do so, and for that specific project and for that duration, so that we are aware that there is architecture professional B who is working at this project, and he's being he's been granted permission to work there for a period of maybe let's say 12 months or whatever that the council may deem fit at that point. We go to Rule 8, where we have disciplinary procedures. So in the disciplinary procedures, this would be, we would be outlining that when we receive a complaint, there is a complaint affidavit on the SECAP website. We, a member of the public, an architect, maybe a registered professional, maybe anybody else who feels that there is an alleged misconduct committed by a registered professional. So it can be a registered professional as well, or a member of the public. He will then fill in the complaint affidavit and thereafter submit all the evidence that they are present. This would be your terms of appointment in writing, your plans, any other evidence, any communication, maybe emails. You submit them to SECAP legal at SECAPSA. Thereon, we provide you with a case number. By providing you with the case number as a complainant, SECAP then takes the complaint. We look at the complaint. We thereafter send it to the registered professional concerned to reply to. From there on, we investigate. SECAP, during the investigation, will be contacting any relevant person that might have been involved in that project or in that alleged misconduct. So this normally, typically would be your estates, your homeowners associations, your council, your municipality, or any other aspect who is involved that we would then be communicating with, trying to investigate. Thereafter, when we of the view that maybe, or you have committed an act of misconduct, wherein maybe you've contravened the act or you've contravened the code of conduct, we refer the matter to the investigation committee, where the matter will be presented, discussed. Should the investigating committee feel that yes, indeed there is an act of misconduct committed, we therefore dispatch a charge sheet wherein you will be required to respond to the charge sheet and alleged allegations on there. You will then be required to respond by pleading to the charge sheet. It's either maybe you plead not guilty if you feel that no, I have not done so, and I would like my my chance to prove myself in the disciplinary hearing. Thereon, we'll schedule a disciplinary hearing wherein you'll have to avail yourself. You have to come with. You can be represented, or you can decide to represent yourself, wherein evidence concerning the case would be led. Thereafter, if you are found guilty, then we would impose a sanction. But if you decide, maybe if you know and you are aware that no, well, yes, indeed, I was at fault, when you are aware of the code of conduct, then you plead guilty, and then the matter is then dealt with in a different way. That's where you don't go to the disciplinary hearing, because you would have known that this is an act of misconduct, and according to the act and according to the code of conduct, yes, you have contravened, and then it will be dealt differently. But if it is not, if you plead not guilty, it means that you're saying that, no, I'm going to be presenting my case as well, and then the counsel or the investigating committee or the investigator got this wrong, and they got this wrong in this way. You would then be we will then give you an opportunity to present your case, and then we will then find out if indeed we got it wrong, or maybe it can go either way. It depends on the evidence that have been presented to the disciplinary hearing. So in terms of Rule 7, let's continue. Sorry, Selena, can you take it back? I was not at I was still explaining. So annually, SACAP receives approximately 150 complaints. So on these complaints, these are the complaints that SACAP would generally receive on an annual basis. But however, we have complaints wherein we dismiss. Let's say we don't have, there is no evidence. Like I said, if your things are, if you're aware of the code of conduct and you've done, you've performed work as per the code of conduct, and thereafter it is obvious that, I mean, here there is no evidence, because I mean, cases get dismissed everywhere, and if there's no evidence, there's no need for us to continue with investigating. There's no need for us to continue, or maybe try to charge you for something that you have actually done your work according to, you understand, according to the code of conduct, according to the act, or according to the building standard, the building regulations. You have discharged your mandate, and there's no reason for us to charge you of any misconduct that we have seen. We dismiss complaints, but on those 150 complaints, that's where we have noticed that it is quite important for us to have this webinar to try to make our RPs aware of the code of conduct, and make it easier for the RPs to how can I say it, to work with the members of the public, knowingly what the code of conduct says, knowingly what the act stipulates, so that it can be, we don't have to, we would have been receiving less complaints if maybe all RPs are aware of the code of conduct and are doing their work as per the code of conduct. So further to that, the complaints are against registered persons who are the complaints are against persons who are not registered persons, and persons whose registration have been cancelled due to failure to pay prescribed annual fees. So the complaints, like I read out there, they are against people, against persons who are not registered. So we have a department that deals with unregistered persons, wherein the person, as indicated by Ms. Gaugelo in the beginning, stating that you are not allowed to use the titles of a registered what is it, technologist, architect, or a draftsperson. You are not allowed to use those titles if you are not registered. So these are the people that we would be, these are the complaints that we'll be receiving. Registered persons, obviously, the people who have been registered, people who must abide by the code of conduct. We receive complaints for those ones, and the persons whose registrations has been cancelled, wherein obviously you are required to pay an annual fee or to renew your registration. So where your registration has lapsed, maybe a year or two, and then we receive complaints that you have done this and that. When we look at our register, we find that your registration has been cancelled. You have been informed as per the act that we will cancel your registration based on the fact that you have not paid your annual fees. And thereafter, while your registration has been cancelled, we received complaints also for people who have done so. So It further goes to say that the majority of complaints are about standard of service, e.g. poor communication. Poor communication is very much important. We received complaints where the RPs have not communicated at all with their clients. A person has just received work. He has submitted the plans to the municipality or has not submitted the plans to the municipality. The complainant is the one who keeps following up with the respondent. The respondent maybe does not take calls. The respondent does not returns his emails. The respondent is not communicating with the client. So we have complaints which are based on that, and it's very much important because you can imagine some complainants have to they have timelines. Maybe some have received a building package from the bank. Some have received monies that they want to build, but the respondent has since gone in May last year. He is not responding until now. What will the complainant do? They submit complaints to us and say, no, we have appointed architecture B, registered person B. He has been quiet since we appointed him, and then we don't know anything. We've paid him money. He has not come back to us. We also receive complaints where the registered person has failed to comply with the building regulations. These are also important. Building regulations are there for RPs to abide by. You have your building regulation. Most of these registered persons are aware of this building regulations, that we should not be finding, maybe if you are appointed, your plans have been submitted have been submitted in May last year. The same things are being addressed on the checklist. You have to go and amend this. You have to go and amend this. It is, and you're not adhering to those regulations. So it's quite important that you are aware of your building regulations so that you can discharge your mandate properly and efficiently within reasonable time. Not to be going back. No, the architect must amend this. The architect must amend that. The architect. There are things that you might not be aware of, but at least it should be done. It must be reasonable. It should not be that you have to be informed by the council or municipality that change this, and then you go back and resubmit. Change this, you go back and resubmit. Well, that's taking time off your client. Will then be having a challenge in how does this architect do this work, because they've been informing him that he must do this and he's not doing that. So we also have complaints in regard to failing to do the work within reasonable time. That is obvious. I mean, it shouldn't be taking you 4 years to just get the plans approved. That's unreasonable time. There's reasonable time where the municipality, what is the reasonable time to get these plans approved based on their approval standards. Then they will inform us, no, this is not reasonable time. It shouldn't be taking this person this much time to get these plans approved. We also have complaints based on misrepresentations. A person calling themselves an architect while they're a draftsperson, a person calling themselves this while they're not. We also have complaints where the intellectual work has been copied. Person has copied someone's work. We also have complaints where fraudulent stamps have been used, where a registered person some of them have stamps, and then they have to stamp on a plan to say the plan has been approved. While it's not approved, we request the municipality to give us details. They say, no, these plans have not been approved, but in our position already that we have plans with a stamp. So that's obviously fraudulent. We have complaints where the registered persons has caused construction to begin without approved plans. Maybe he's saying, maybe by then he's a principal agent and hoping that no, the plans will be approved, and then now he wants to get on with the construction, because building construction must commence after the plans have been approved. If the plans are not approved, then we cannot start construction, unless if maybe the plans are approved and thereafter there is a need for construction drawings. That's a different story, because the plans would have been approved initially, and then during the construction, we then find out that no, amendments must be made. Then those plans will then be submitted as built plans. But then prior that, plans must be approved, and then construction must commence. We also have complaints wherein the registered persons has changed the scope of work without the approval of the client, wherein he has decided, no, here this wall must be moved, it must go there, or these windows, any amendments, because the house you're building, you are building the house for your client, it's not yours. So what you must do is that you must get approval from the client. You advise the client, no, look, according to my experience and my expertise, this wall cannot be here. The client will then have to look at it, and then the client will have to say, okay, fine, let's do that. But not on your own accord, you go and change the walls and change the design and change, because they want to build the house of their dreams. And if you're going there to amend the scope of work without informing them, that is, it shouldn't be like that, because we all have to do as those people are our clients, and then we must do as they have instructed us to do so. So now we can move on to the next slide. And we also have cancellation of registration. Well, this is it's very much important. Section 20, subsection 1A, Roman figure 3 provides that the council may cancel the registration of a registered person if he or she fails to pay prescribed annual fees within 30 days from it becoming due, or within such period the council may allow. So as you've noticed, last year with the pandemic, the council allowed registrations to be paid later during the year, unlike previously where registrations were supposed to be, where annual fees were supposed to be paid in April. So if you have been informed by the council that you should pay annual fees within 30 days, council will cancel the registration. That's what my colleague was explaining, that if you have not paid your registration, your annual fees, council will have to cancel your registration, and you will be deemed to be unregistered at that particular time that you have not paid the registration fee. So it is very much important that you pay attention to the emails that you receive from SECAP, that you are in good standing with SECAP, your registration is in good standing, you have registered, you have paid your annual fees, because it can be quite costly also to your clients, where you have performed work while you're not registered, and then when you submit plans to the municipality, and when they punch your registration number, you are not registered. Your client is ready to build, but then you're not registered, and you cannot go back to your client and inform them that, no, I was not registered, so now I want to get registered, I want to pay. Because if you've been registered for quite some time, you must follow through the re-registration process, and it might even take maybe more than a day or maybe a week for that matter. So what would it be to your client if you have not, if you are failing to discharge because of failing to pay your annual fees, you understand? And then by the time we then record it as a non-registered person, because we don't know your intentions, because you've been given 60 days to try and pay your annual fees. So section 20, subsection 3, council must at a written request of any registered person to cancel his or her registration. So can you move on to slide, next slide, please, Serena. So this is candidates. This section deals with candidates. So section 18, subsection 3 of the Act, read with Rule 2.3, states that a person registered in the category of candidate must perform work in the category for which he or she is registered under the direction, control, and continuous supervision of a registered professional entitled to perform such work, and who must assume responsibility for any such work performed by the candidate. It further goes to say a candidate cannot have any pecuniary interest in the practice other than in the respect of a bona fide remuneration for his services. So this means that a candidate must just only be there to perform architectural, he must only be there to work as a candidate to gain experience and for his remunerations to be, that will be the only, that will be the only interest that you must have for the architectural practice. Let's move on, Selena. Can you move on to the next slide, Selena? The council is mandated to regulate the architectural profession for the benefit of the public. This is for the benefit of the public. Members of the public are entitled to receive quality architectural services. The council is required to protect the reputation of the architectural profession by ensuring that all persons offering architectural services are registered and are in good standing and ensure the compliance with the rules of and regulations. Let's move on, please. Selena, can you get to the next slide? Yes, and this would be the end of our presentation, and we would allow questions and answers to be brought forward by the attendees, and then we can answer those questions as they come. All right, maybe Gaugelo, can you take us through? Thank you.
Thank you very much, Ntanga, for the presentation. We've now come to the end of the presentation that we had prepared. I'm now going to allow for questions. The questions will be taken from rule 1 until to the last rule. I think it will be appreciated if we can get questions starting from rule 1 until the last rule, so that we are able to clarify each and every rule that has been put there. And if need be, we'll also give examples of cases that we've had in the past that relates to the rule. So, Munezi, I don't know whether you are there. If we can open up and allow the attendees to start asking questions. I know that some of the questions have been posted on the platform here, and some of those questions we've responded to them. The purpose of this engagement is really to educate each other about the rules and the code of conduct and what is expected from professionals when they undertake architectural work for the public. So I'm opening up for questions. Any question with regard to the code of conduct is allowed. I see that there's a hand from Rishi. Rishi, let me take your question. Rishi, can you hear me? I don't seem to hear anything from Rishi. Nadim Naidu, can you take your question? Let me try Mr. Nell. Mr. Nell, can I take your question if you can hear me?
Thank you, Advocate Fuduli. Thank you very much for a very beautiful presentation and your reach out to help.
Hold on. You're actually talking and we're not on meeting anymore.
Mr. Nell, you can go ahead. Nadine, if you can please mute for now so that you can allow Mr. Nell to ask the question.
Can you hear me now, Advocate?
We can hear you very clear and loud, yeah.
Thank you very much. As you know, I'm the president of GIFA, and we represent our members and architects in general. I am very grateful for your reach out to the profession and attempt to make people aware of the actual idea, the new code of conduct. I have developed about 35 questions around the presentation, which I'm not going to hold the whole group up on. We'll communicate them to you afterwards. I do have some pertinent questions. The first one for me is, what is SACAP's prognosis on the IDOW at the moment? Because it seems very unfair to us that you regulate the profession without regulating yourself. That is something that's important to us. We believe that this is a CPD category registrar, CPD 1, category 1 event. Just for interest's sake, how many RPs are at this event and who did the CPD accreditation? What is the exact date of the publication or gazetting of the new code of conduct? We are very concerned about overregulation of some of the registered persons that do not necessarily fall into the PRR category, and that may inhibit growth, particularly of the non-PRR categories. We are concerned that RPs, in terms of disciplinary action, are not fully informed of their rights. For instance, having access to legal professionals when they get a notice that there is disciplinary action against them. We believe they shouldn't only be informed or advised, they should be advised that they should get legal representation. And particularly in cases where the professionals admit to guilt and only get a fine after that, because there should be a process of negotiation between them, between the professional, his legal representative, and SACAP before a fine is applied. In talking about honest representation of work, I'm afraid to be very pernickety about terms, but we shouldn't let people use the word practice architecture, as you did in your presentation, but rather refer to architectural work, because the only profession that can practice architecture is PRArchs. That is something I just want to qualify, and we don't want people to call themselves architects when they are draftspersons. So I think we must just check our own technical language when we do presentations. We believe that some of these new code of conduct rules are particularly onerous, especially as it goes to getting approval from the client. Anybody in the industry will know that it can sometimes be impossible to get anything in writing from the client. And we believe that some of those rules could be that you inform the client that this is what you're doing, and the client should also have responsibilities, for instance, letting you know in writing what they'd like you to do. Thank you for the opportunity, my leader. I'm going to write to SACAP and copy Saya in on this, but thank you for a very interesting presentation.
Well, thank you very much, Mr. Nel. I think I'm going to address a few questions, and then I'll allow the team as well to come in and address some of the questions. But I think just to start off with the IDOW, although the IDOW is not part of today's presentation, but I'll answer that and say that you'd recall that the biggest issue that the profession faced with regard to the IDOW was the Competition Commission, because they believed that the IDOW actually is an instrument that allocate market and allocate work, and that is a contravention of the Competition Act. And in the past, the previous councils applied for what we call an exemption. They wanted to be exempted from the Competition Act insofar as IWW was concerned. But the current council, together with the CBE, have taken a different approach altogether, because they believe that SECAP is entitled to publish the IWW to regulate the profession. And the commission as well has been brought on board to work with us to ensure that we publish the IWW. We've had various meetings with the Competition Commission. In fact, this is the only, SECAP is the only council that actually made comprehensive submissions, written submissions to the Competition Commission with regard to the guideline professional fees, as well as the IWW. And following that submission, the commission has now come back to us and say, look, we understand where you're coming from. We understand your legislation. We understand that you have a mandate to regulate the profession. Therefore, we will not prevent you from publishing IWW or fee guideline. However, we need to work together to make sure that those instruments are not used to exclude people who are competent and qualified to perform the work, or those instruments are not used to fix prices. And I think we're on the same board with the commission with regard to that. In fact, we are now on the verge of signing an MOU with the Competition Commission to make sure that we work together to address some of the concerns. And their biggest concern has always been about transformation. Their biggest concern has always been about the profession must be open to anyone who is experienced, who is competent to perform the work. Nobody must be excluded from the profession. So I think we're very much advanced. I think very soon, probably before the end of this financial year, we would have published the IWW and would have an MOU with the Competition Commission. So I think with regard to IWW, SECAP has done extremely well. Things are very, very advanced from there. With regard to the issue of CPD, you must remember that as much as VAs accredit CPD, SECAP as well has authority to be able to be able to run training to the profession and be able to award CPDs. This is in terms of our CPD policy. So SECAP does not need anyone to come and accredit the presentations that we are doing on the code of conduct, on the CPD, on the IWW. We don't need any accreditation. So I hope that is clarified. The code of conduct will be published, I think, in the coming, probably this week, because we've resubmitted the code of conduct and the rules of inquiry to the government printing department for publication. And then I'm going to leave the questions of RPs not being fully informed about their rights to the team. And also, I think I've noted that you prefer the use of the word architectural work rather than practice architecture, which is it's noted. And then I'm also going to leave the question on the rules, that the rules are onerous to the team as well to answer. I hope I've clarified those questions.
Thank you. Thank you very much, Advocate.
All right,
That's
thank you.
Absolutely in order.
Ndanga, are you at the floor?
Yes. Thank you, sir. Yeah, thank you, sir. So you asked about the respondents not being maybe made aware of their legal rights. So when we send out the complaint to the respondents for them to respond to the complaint, we do inform them that they can either represent themselves or they can be represented by a legal professional. And some even went to a point of getting VAs to represent them. So we do inform them on the letter. Thank you. Thank you so much.
Thank you very much. The next question is the rules that are onerous. Tabani,
Can I come back to that question, please, Advocate?
all right.
I was specifically referring to the idea that registered persons seem to often be asked to admit guilt, and then after admitting guilt, they're informed of the quantum of their fine. And, you know, this is in terms of natural justice is not something that I think is fair on their RPs. I think that they should be informed that before they make a guilty plea, that they should have a process, preferably with a legal representative, to negotiate that with SACAP. It just seems unfair that I've worked with people that I help with SACAP issues as president of GIFA, but that they often make, they think, oh, well, it's going to be an easy process. I'm going to admit guilt, but very often afterwards, they can have a fine of 70,000 Rand or more. And that seems to only become, they only seem to become aware of that after they've pleaded guilt. And that seems to be a problem for us in terms of natural justice.
Okay. No, I think we hear that, but our normal practice is that the RP is served with a charge sheet and given an opportunity to plead. And in most cases, we always say to them that, look, it is best to sit down with the legal and compliance officer, engage on the actual charges, and see which ones you think you might have contravened the rules. And then from there, if you admit guilt to any charge, each and every charge is linked to a particular fine. So there's no way that you can find after a settlement agreement has been signed that this is the fine. You'd know during the engagement. So, but I think we'll advise investigators to make sure that this information is there upfront, so that the professionals are fully aware what they're getting themselves into. But so we take note of that. Thank you very much.
Thank you very much, Advocate. And is there any way that registered professionals can have access to the quantum of fines that you say are regulated by you? Because I don't.
Yes, what we'll do, perhaps in our website, we'll make available the sanctions, the sanction guidelines that's used, which is aligned to the legislation.
Thank you, sir. Thank you, because that information is not freely available to people that deal with disciplinary action.
Okay.
That answers my question. Thank you very much.
All right. No, thank you very much. I think there was also the issue of the rules that I think you said the rules are onerous, but I think if you listened, I think there was a presentation that one of the reasons why rules are changing is because of the complaints that we are receiving. There are clear patterns that there are gaps that needed to be closed. So that's why you find that these rules are there, because we've seen that there's a challenge in the profession, and members of the public are the ones who are complaining. So these rules are really a response to the public. Some may find them onerous, some may find them helpful, because if you really comply with the rules as they are, you avoid many trouble. You know, if you're going to amend work without an approval of the client, you know, you might get away with it, but in the future, and this thing comes up, then you're in trouble. So better make sure that you get approval all the time, and then you're on the safe side. So that's how we see these rules. I think let's see them in a good light rather than in a negative light.
I fully agree with you, Advocate. I'm just saying that some of the rules that you're putting there, like getting approval from your client, it doesn't say get approval in writing. But in practice, it is particularly onerous to get approval in writing from somebody. And getting that approval can often hold up a project by 2 weeks to 2 months just to get a written approval, okay? Because clients aren't very happy to put things in writing. So, but, you know, I accept that we only have limited time, and we will write to you copying Saya in on this to see if we can refine this, if it's not for this code of conduct, for the following one.
All right, not a problem. Thank you very much, Mr. Nell. Thank you for questions. I'm gonna take the next hand. Nadine, Naidu, your hand is up. Let's take your questions. Nadine, are you still there? Okay, I'm going to take the following hand. David. David, we taking your question.
Hi, can you hear me, Advocate?
Yes, we can hear you.
Hi, Advocate. Yeah, I just wondered if there was some way that I could find clear guidance on the difference of the requirements for a company or for an architect registered as a company or CC versus an individual practicing, and whether that's on the SACAP website or whether there is an individual that deals with that to ensure that you have dealt with all aspects that you need to in respect to your registration.
All right, so basically, just to answer you, basically, there are different forms of doing business that are recognized by the Companies Act. As you correctly said, you've got a company, you've got a partnership, or you've got a sole proprietorship. Before the Company Act was amended, we had a closed corporation, but now closed corporations have now been done away with. So currently, we've got the companies, and we've got those sole proprietorship, and then you've got partnerships. But you must know that a partnership and a sole proprietorship do not need to be registered. You just carry on conducting your business. But if you want to have a company, it must be registered with CIPC. Am I correct? Yes. And then in terms of our rules, Rule 5.1, it requires that a registered person who practices architecture in any form should inform SACAP. So if you know that you're practicing as a sole proprietor, you need to write to SACAP and say, I'm a sole proprietor, I've got the following employees in my practice, and make sure that you provide that information to SACAP. That applies as well if you are in a partnership and also if you're in a company. But you can send me an email, and then we can be able to address your issue and help you.
Okay,
that's fine.
That's fine. Yeah, and then I've got a second question, if that's okay.
All right.
Obviously, often small practices, we end up being a small practice, and then at times we need to contract additional staff in for something that we are working on that's maybe beyond our usual scope of size of office. Is there anything that we need to do in respect of that? If we are, say, for example, a company, do we need to inform SACAP, or is that just in the normal course of our practice?
Well, I think that will be the normal course of your practice. You just have to comply with the Labor Relations Act. But if you have to contract temporary employees because we've got a bigger project, you are not required to inform SACAP unless if now you are employing those employees permanently. You just have to inform SACAP that I've got this number of employees in the practice.
Okay, that's fine. Thank you very much, Advocate.
Thank you, no problem.
Advocate Faduli?
Yes, sir.
I just think that, we are putting more and more pressure on practices, but I also think that the registered person should have a duty to inform SACAP if they move away as well. I mean, yes. SACAP eventually does regulate registered persons and not practices in terms of the Act. So I think that we must be clear that there's a responsibility on the RP that must be more onerous than that of a company.
Okay. Oh, thank you. That is noted. I'm going to move to the next hand. Nadine, are you still?
Hi, good morning. Sorry, I just
all right, no problem.
My computer froze earlier. Thank you for the webinar. I think it's fairly informative. I just had a point in terms of the municipal approval process, in terms of who is holding the municipalities to account. Municipalities by law have 30 days to give us written feedback.
Yes.
This often doesn't happen. And then on top of that, often there is information that is submitted that is overlooked, or in my view, there is an incorrect understanding of the national building regulations and what is required to be submitted. And it can be very frustrating as a person who actually understands the building process and the building and what actually goes on site, dealing with somebody who feels like they are law unto themselves and you don't have a choice. You either do what I say or your plans don't get approved. So, you know, who's holding the municipality to account? Because it's extremely frustrating for us when we have, you know, I'm a small practice and we spend a lot of time doing high quality drawings. I also lectured in the School of Construction at WITS for 8 years. So I'm very particular about technical drawings, and I've seen some of the technical drawings out there that are really not great. We really spend a lot of time on that. And then to kind of have to go through a process where I almost feel like I have to explain to somebody, no, there's that note, there's that, not getting my feedback in 30 days. And that delays me. That delays me getting to appointment on stage 5 on site. It delays my client. It delays the whole process. So that's my question there. That's my first question, just in terms of who's holding the municipalities to account. Because yes, we have a timeline, but I put my hands up and I tell my clients I can do everything I can. Beyond that, I can do no more. It's a government department. It's out of my control. My second question would be, as a PR org, what is SACAP actually doing to protect me? You know, I can go onto LinkedIn now and I can go and find people who either through a mission or just blatantly are calling themselves professional architects and they are not. And I think the general public doesn't understand the difference between an architect, a technician, a draftsperson. I don't really know what all the categories are, so I apologize for that. But surely if SACAP's mandate is to protect the general public, then SACAP's mandate should also be to educate the general public. So sorry, that's a two-tiered question. What is SACAP doing in terms of that, in terms of people who are essentially falsely, either directly or through a mission, not being clear about their qualification? And what is SACAP doing in terms of educating the general public in terms of these different levels of qualification?
Okay, thank you very much, Nadine. I think just to answer the first question, I'm gonna leave the second question about educating the public to our SR manager and Dogozo to answer that question. But just to look into the first question, we do not have authority over the municipalities, but what we have done as SACAP is to work closely with them. We've recently entered into an MOU with the city of Johannesburg, the city of Mangaung. We are currently engaging with the city of Cape Town. So, and what we're trying to do, we're trying to work closely with them to make sure that they comply with the NBR. Because what we've noted is that sometimes the plans just take forever before they can be approved. You know, there's no compliance with the 30-day or 60-day requirement. So we are working with the municipalities. We're hoping to at least encourage them, you know, to push them to comply. You know, recently I've been receiving concerns from an RP who submitted the city of Joburg about a delay in approval of plans. And we escalated them to the BCO, who then escalated to the plan examiner to try and push the process. And the good thing is that that plan was looked into and they're able to assist him. So that's how we will try to get into the municipalities, solve the problem that our RPs have. The same applies to the city of Tshwane. We do have an MOU with them, and we'll try our best to try and push them to comply with the NBR. And I think these MOUs are good tools in our hands to work closely with them to make sure that we address some of the concerns that most of our RPs have with regard to failure to approve plans on time, or just being slack in terms of, you know, attending to applications or not even acknowledging applications, you know. So those are some of the things that we always, some of the complaints that we always get from the profession. And then I think I think the issue of people promoting themselves as RPs on LinkedIn and various social media platforms, SAGAP has always taken a stance that conduct is improper. It is a contravention of our legislation. It just tantamount to fraud and a clear misrepresentation. So, and that's why we're working directly with the South African Police Services to try and report these people, these fraudsters. Unfortunately, sometimes the cases take a bit long, but we do take action against these people. And we encourage anyone who sees anybody who's misrepresenting himself or herself to report such to SACAP so that we can take those people on, report them to the law enforcement agencies, and also contact them and request them to stop what they're doing because doing is illegal. And then I think the last part of your question, I'm going to leave it to our SR manager, who has had many campaigns to try and educate the public about the profession and so forth. And Ntokozo, are you with us?
Thank you, Advocate.
Thank you, Registrar Advocate Fiduli. And thank you for your question as well, Ms. Naidu. If you were following our social media platforms, we've been engaging on public awareness campaigns, municipal workshops, and we have visited various municipalities, and on those municipalities we were inviting even public to attend those municipal workshops. But however, since the pandemic, we had to stop any public event that we were having, and we've been very active on social media platforms where we share information to raise those awareness to public and informing them. And we still have the plan to visit public areas, and as soon as the regulations have been eased, we will definitely roll out that project in partnership with some of the municipalities and the VAs that we have engaged. So it's a project that is in pipeline, and there are activities that are currently happening to educate the public. I believe I've answered your question. Thank you.
Thank you very much, Ntokozo. Nadine, I hope your question has been addressed. I'm going to go to the next hand, which is, let's see, Gio Klute.
Hi, good morning, Gio Klute. Good morning, everybody.
Sorry.
No problem. I've got 4 questions. Well, the one would be where it was mentioned that a person can't call him an architect if he's not registered anymore. I think there should be a differentiation between a person being an architect and a professional architect. Because if we take it in conjunction with, say, another profession like a doctor, the moment you're not working as a doctor anymore, you're not losing your degree. We all have worked hard to obtain our degrees, so that can't be taken away from a person by just not being paid out. So I think that needs to be written in, that there's a differentiation between a person who has a degree in architecture or architectural profession, and then being a professional architect, being allowed to be working in the profession. So that's point number 1.
Okay.
Then point number 2 is it's very refreshing and reassuring to hear today for the first time that SACAP is actually saying that they are taking on the role to also taking the professionals side as well, or to protect us. I think what needs to be looked at is to further that protection is, it's fine to say that only people who are registered can practice and see that as a means of protecting us. But that's very limited protection for us. I think that just brings in more money into the coffers of SACAP. What would help us in the industry would be to get to the point that people are at least in a very small margin working to the same fees when they quote for projects, because that is where there's a big dispute in the industry, because people is so undercutting one another, and that is what's killing the industry, and what at the end of the day makes it difficult for us to meet obligations like paying rent, putting food on the table, and paying our fees. to SACAP.
Okay.
The third point, I think there needs to be a little bit of clarification on the term of scope of works. If I have to get permission from my client for every change I'm making as I'm going through the design, then the client must become the architect. I think what scope of work means is, for example, if I've been commissioned to design a 3-bedroom house and I go as an architect and all of a sudden decide to add another 4th bedroom, that is change of scope of works. But deciding on the size of the window or where the window is going to be in the wall, that's part of the design process, and that process will be approved by a client as the design is being presented to the client. So I don't think scope of work includes, or change in scope of works is changing, say, a number of windows or the size of windows, or things like that.
Okay.
And then the fourth and last point is just, it would be dearly appreciated if with these workshops that SACAP undertakes, is like, we know now that the points is allocated in category 1, but we don't know the number of points we're getting or the percentage of points we're getting. So if we can have that advertised up front as well, so that we know when we set aside a day to attend, that we know what the points is that we are getting. Thank you.
Thank you very much for those comments and questions. I think we take note of all the comments, particularly about the issue of suspension and cancellation. We do accept that regardless whether your registration is cancelled or not, you still have your qualifications. However, for you to be able to call yourself a professional architect, a professional senior architectural technologist, you must be registered and you must meet all the standards of the profession.
Yeah, I 100%, sorry to interrupt it, but I 100% agree with that. If a person calls himself a professional architect or professional senior technologist, whatever, they must be registered. But
yes,
it was just in the presentation earlier, it was mentioned just the word architect, and the professional portion was not included. And that's why
okay.
I raised the point.
No, thank you for the correction. We really appreciate that. Well, I'm going to give you an opportunity to come in. Let me finish. Let's finish addressing some of his questions, and then we'll come back to you if you want to have additions or any clarifications. Will that be fine with you?
100%. Thank you.
All right. And then I think you raised a very important issue about the issue of professional fees and the issue of undercutting. And I think SACAP president has addressed this issue on various occasions, that the issue of undercutting is really killing the profession. We hear that people are actually discounting as far as 60%, 40%, 50%. And the president has come out very clear that that is not sustainable for the profession. So SACAP really has to be able to educate professionals about the importance of making sure that your fees are able to cover all your costs and also be able to make a profit from the work that you are doing. It is not acceptable that you undercut to the extent that you are not able even to cover your own costs. And obviously, if you undercut to that extent, the quality of work that you're going to produce for your client certainly is going to be affected. So those are some of the things that are serious concern to the profession, and I think we thank you for raising that point. The third point that you raised was about the scope of works. I fully agree with you that when coming to the change of scope of works, there must be an approval from the client. But as you say, in terms of design, which window fit where, how it must face and those kind of things. Those are things that fall within the ambit of the professional, and the professional must handle that without having to go back to the client and so forth. So I think your understanding of scope of work, we are together there. The investigating committee together with the council agree with you. So we should be fine there. And I think we also take your point, the CPD. Thank you for the point. I think next time we'll make sure that we put all the information out there. Let me allow Mr. Nell then to come in with clarifications or maybe questions following your questions and your comments.
Thank you again, my leader. I think that in terms of the architectural degree, which is either NQF 8 or NQF 9, that would put us in the sphere of advocates and specialists in the medical profession. And I think the title architect has been a little bit confused with the title architect, which was used post-nominally before, according to British standards. And with your approval, we're now working at SIA to get that a pre-nominal title to fit more with what is the practice on our continent. So we are at SIA, we are lobbying for people that are professional architects to call themselves architect MPEPU, and then after that PR-Arch. But the two shouldn't be confused with one another. The one is a title for life, like professor or advocate, and the others are SACAP registration qualifications. I hope that qualifies, and I ask my colleague to work through his VA to find out more about the pre-nominal title, which we are using to clarify this to the public, which will also make SACAP's work easier. In terms of, and you must feel very free to disagree with me at any point. In terms of scope of works, that is a very complicated issue. In very large projects, to get a mandate, we recommend to architects to always get a written mandate from their client. It's very difficult to develop the client's brief and then continue on that without getting their approval on that brief, because that means that you're actually writing your own mandate and the client can disagree with that later. So a written mandate from the client is very, very important, because that is your mandate and that is your scope of work. In this, they can be alerted to let you know in writing if they want any changes, and if they fail to write to you in writing, then their case will be not as strong if they have a disciplinary action against you.
Okay.
In undercutting of the professions, we are very concerned that the biggest part of this is actually coming from Department Public Works, and that they are appointing people to work at rates that are in 20–30% of the SACAP rates. And this process of tendering is very, very, very damaging to the profession, because 60 or 70 architects could do a proposal for Department National Works, and that they appoint the lowest one, in fact, then doing 59 or 69 people out of their fees for stages 1 and 2. So I think that the Department Public Works should be alerted to the damage that they are doing to the profession. The other thing, I just want to circle back to the IDOW and the Competitions Act. At IFA, we've been wondering if the best way of solving the issue, because it seems like SACAP and CBE is trying to deal with the Competitions Commission. The Competitions Commission falls under Minister Patel and Department Trade and Industry, and SACAP falls under Minister Patricia de Lille at Public Works. And we believe that these two ministers should get together and be alerted of how their lower departments are squabbling with one another and not getting results. And we wonder if getting the ministers involved won't in the future facilitate your obtaining IDOW in a better way. Thank you.
Thank you very much, Mr. Nel. I think just to clarify your last point on IDOW, I think we've reached a point where the CBE, SACAP, and the Competition Commission are now on the same page. In fact, there was a meeting which the Competition Commission arranged with Minister Patel with regard to the issues of IW and the fee guideline. And all those meetings went very well, and all the professions were represented. And that's why I said earlier on that we are now on the verge of publishing the IW, because the Commission, the CBE, DPW all agree. We're all on the same page, and the Commission is certified that their recommendations that they've submitted to us as SECAP to consider before we publish are actually being implemented. So I think we have now passed the stage where you have CBE, Competition Commission not being able to find each other. So we might not even need to include now Minister Patel and Minister of DPW, because we have now resolved our issues. But thank you very much for those points, Mr. Nel. They are really appreciated. Let me move then to the next hand, which is Catherine. Is it Catherine?
Yes, that's me.
Yes,
hi.
Catherine.
Good day, everybody. I just had a case, and I was wondering what SACAP would be saying about this. We put an SDP into the City of Cape Town, which got approved, and then our clients sold on the project. I've since heard, I since phoned the council again to find out, was the project, we found out that the project is now going into the council phase to be approved. But it appears that the new client has taken our drawings and run off with them, is not paying for them. I tried to contact the City of Cape Town, and they flat out refused to assist me and said that we need to be a direct neighbor to actually see the plans, to see whether our plans, I just wanted to view the plans to see if our plans were being used. And the City of Cape Town refused to help me, to say that their reason being that I'm not a direct neighbor. That's where I'd really appreciate SACAP help or advice on something like that. Yeah. So how do we go about that? And shouldn't a rule be changed? So if an architect had done the drawings for that site, surely I should be able to look to see whether that person is now using all our documentation, and not when we are not being paid for that. And I've lost all my staff during COVID and everything, and now I can't pay my staff, or so it's the architect is always the apex, the top of the pile, and if we don't do well, then the technicians don't do well, and everybody below us all suffers. So I think from our point of view, if we get our fees, we can pay everybody down the line. So yeah, I just felt very exposed and very upset that we're probably being ripped off by somebody else, and we have got no protection.
Yeah. Okay. Thank you very much for that for that question. I think from our side, if you looked at the new rules, there's a rule that requires that if a professional is appointed to a project where there was another professional, that new professional who's now coming into the project must verify with the client that the previous professional has been paid the fees for the work that has been done. And one of the reasons why that rule is included is because of this particular case. There are many cases like this that we get from time to time. You find that a new professional has just been brought in, and the work of the previous professional has just been used, and there's no payment for that. And we view that as very unfair and very unacceptable. It's a clear infringement of the copyright laws in this country. But I think as a way forward, what we will do from our side, we'll get in contact with Marius, the BCO, the City of Cape Town, and be able to see how we can address the issue. So what we can do is I can simply take your email address, and then from there we'll communicate and see how we can intervene and try to make sure that your work is not being used without you having been paid for that work. Will that be fine with you, ma'am?
That would be wonderful. Thank you very much. Very, very much appreciate that. Thank you.
Yes, if you can just drop us an email address.
Okay, lovely. I will definitely do that. And then the other question that I have, just if I may, what sort of mistakes do architects typically fall into? Maybe if you could, after this, maybe send a sort of circular of what, like, you said you had 150 complaints about our service to the public, and what sort of typical traps that I'm sure we don't intentionally do it, but I'm sure we do repeat errors. And I'd like to know that, because I wouldn't like to fall into that sort of trap. I've never been accused of wrongful doing or anything like that, but it would really help if I knew what people kept on doing wrong.
Yes, no, thank you for that question. That question is really welcome. In fact, let me do this. Let me allow the legal and compliance officers just to to name or just to outline most of the complaints that we receive, because they are all the same, as you correctly say. And if we take heed of all those suggestions that we've said earlier on, we'll avoid all these complaints. So let me allow Khaukhelo and the team and Danga and Bessie to come in and just outline some of the complaints that you receive.
Thank you, Chair. I'll also allow the team to answer after me, but a big one is 4.1, the requirements for written agreements. Now, the issue that you find with most of our complaints is that the agreements that architectural professionals enter into with their clients does not always comply with Rule 4.1. So it's very important to make sure that you do have all the requirements that are needed as far as the written agreements when you do enter into these contracts. Make sure that there is dispute resolution. Make sure that you do show your professional indemnity insurance and all those types of things. Another big one is notifying the council on the establishment of a new practice. That's like a standard thing that we even check now. We check the contract and we check if you've notified us that you've established a new architectural practice within 30 days. That's something that I think a lot of people should also notify, because that's a very common one to think. I'll allow my colleagues to add other things that they've come across.
Just before you come in there, just to amplify what Tabani said on Rule 4.1, that's a common contravention. However, I know that SAYA, they do have an agreement which complies with Rule 4.1. SECAP as well has an agreement which complies with Rule 4.1. So all you have to do is simply download that agreement and simply tick what's relevant to you and comply. Thank you.
With regard to the examples of the complaints that we usually receive, most of the ones that we receive is abandoned projects. And also we have complaints of not adequately communicating with your clients. For example, we have complaints where we receive, like a client will come to us and say that I've paid so-and-so a certain amount of money, and I was expecting them to do so-and-so, and I was expecting to have received an approved plan already, and I've paid the money, and I'm expecting to receive a service. And then we have RPs who are not adhering to the agreement between themselves and their clients. So we have those type of complaints. And then we also have complaints where clients are complaining about not getting updates from the RPs. Like someone gives you a project to do, but you don't go back to your client and say, no, now the plan is completed. I've submitted the plan at the municipality. There's a referral letter. I'm attending to a referral letter. So we have clients who are complaining that RPs are not adequately communicating with them. So they don't know what's going on in their project. So those are the types of complaints we receive. And we have where an RP doesn't attend to the referral letters. There's a referral letter that came from the municipality. It was delivered at the RP address, but now the RP is failing to amend the plans as per the referral letters. So we have like an obligation type of complaints that RPs are failing to do their obligation as per the agreement with their clients. Yes. So I don't know if maybe the team will outline on other complaints that we receive.
Just to add minor complaints, we also receive complaints whereby the member of the public is complaining that the appointed professional is failing to comply with the regulations or the bylaws, whereby, for example, they've submitted a plan and over again, they're receiving referral because they did not understand what the bylaws specifically to that area. We also receive a lot of complaints whereby members of the public are unhappy with the time period of the service, whereby a professional will speak to the person and say, no, I expect in 2 weeks or in 4 weeks, I'll be done with this project. And that does not actually become the case. And then they come and say, you know what, over this month have passed or over this year has passed, and I still don't have the approved project. So it goes back to updating and communicating. We also receive complaints from members of the public whereby they are of the opinion that they have appointed registered professionals. And when they come to SACAP, they realize that, you know what, they actually had appointed unregistered persons, which goes back to basically us informing the public that they must always inquire with SACAP prior to employing people. The team can add further if they have any other types of complaints. Thank you.
Can I add to that, Advocate?
Yes, sir. Go ahead. Yeah.
I think it's very important for the RP to clarify to his client that he is not responsible or empowered to actually force a local authority to give him approval. However, attending to letters of referral is very important. But in general, very often the public doesn't understand the difference or the complications of getting local authority approval. And I think it's just important that the registered person allow for a certain amount of attendances to the councils to get approval, and not leave the client under the impression that this is just a very simple administrative issue, because it can get very complicated.
No, thank you, Mr. Nel, for that. Any other comment from the team?
Okay, maybe if I can come in there, I think one important one would be to make preliminary inspections of the site. We receive complaints wherein a complainant will be saying, no, the architect should have known. You see, when you are starting a project, obviously the title deed will be there, will be showing the restrictions. If there's services, you inform your clients that no, there is no sewage services, there's no, because now when the plan is approved, and then we find that there are things that an architect should have known before drawing the plans, it becomes a challenge as to say that you did not do maybe preliminary investigation on your work, and then you then end up producing plans which do not comply, and then the client cannot do anything with the plans. So preliminary inspection is very much important. You look at the site, you look at the title deed, you look at what you are supposed to and what you're not supposed to, depending on the type of project that you're going to be dealing with, so that when you go on further, the plans do not become useless to your client because they would have paid. So preliminary site inspection is very much important, and regulations governing your site. Thank you.
All right. Thank you very much for that. I think we have covered the majority of complaints that we receive. But I think what we'll do is we'll prepare a summary of all these complaints that we receive, and then circulate them to all the attendees, so that at least you know what are the complaints that you are receiving, so that you can avoid them in the future when dealing with your clients.
Advocate, can I come in on that point again?
Okay.
Advocate, can I come in here, please?
All right.
Advocate, can
before
I
you come in, let me finish with Mr. Nell. Before you come in, let me finish.
Mr. Nell has come in quite a bit, but I've noticed that we are not given a chance as a VA.
Okay, go ahead.
You
go ahead.
It's very, very unfair, and I think this is a code of conduct forum, and I think we are actually going out of context of this meeting, and I think it's getting a little bit frustrating that people like us who are affected by this code of conduct and the professionals are not given a fair chance. It looks like we're just going with a particular VA and SACAP is unfair.
I take great exception.
Can I finish what I'm saying? I haven't mentioned a name. I haven't mentioned any names. I'm saying.
Okay, colleagues,
that
Ray,
this
please. Ray,
advocate,
please. Can let's work together. Okay, your chance is coming. Just hold on. Just hold on.
Right. But
Can-
all I'm asking for is afford us to put in our questions.
Yes, I agree with that. But before you proceed, can I just request that we respect each other and work together? I was giving Mr. Nell to come back on the point which was raised by the previous speaker, and then your hand is the next one that's coming now. If you can just please hold.
I haven't picked on any particular person. No, I'm not mentioning names.
Yes,
I'm just
that's
asking
fine.
afford us fairness.
Yes, all right. I accept that. Okay, let's move on then. Mr. Nell, do you have a point that you want to make before we move to Ray?
Yes, I do, Advocate. I think that the registered professionals are very often burdened with things like site inspections, etc., even prior to their appointment. I do think there is an opportunity to have a pre-appointment fee for inspections on an hourly rate. And that is something I think we should investigate, because as it currently stands, the registered professional, all of us, not just architects, are burdened with doing site inspections and coming up with a brief, and nobody actually pays for that service. I think that there's ample scope to develop a pre-appointment fee or an agreement. In other words, for the time spent before I get appointed. This also includes developing a brief, which can take up to 3 years for big projects. I also just want to say that I absolutely take exception to what is happening here, because in far as I have seen, SACAP has not been unfair to any other category of registration.
All right. Thank you very much, Mr. Nell. I'm coming to you, Comrade Ray Ramlal, as I normally call you. I'm now giving you an opportunity because your hand has been up.
Thank you, Comrade Advocate Fuduli. Thank you. I think it's very important for me. I'm going to refer to clause 1.4, but before I read this out, I understand that we are living in a very competitive society. At the same time, this competitive society, contributes towards the economic situation. I see Rule 1.4 a little bit out of context, in a sense that it is a three-sided code of conduct where it should be four-sided, because we are now affording government to do its own things because they are permanently paid staff and they don't do the work at the municipalities. Now, I've just heard from you earlier, Advocate, that you said that you are basically wanting to enter into an MOU with the municipalities who are delaying the professionals' work. And they are getting paid permanently, even if they didn't approve one plan. And you are talking about entering into an MOU. They should be included strictly in this code of conduct, because we cannot have a competitive society to build up the economy if the government workers are getting a fat salary and not doing the work. They should be fully under the code of conduct. Thank you. And this applies to 1.4, which I see as a three-sided matter, and it should be rectified before it goes to be publicized, for the public. Thank you.
Thank you for the comment, Mr. Ray Ramlas, comrade. I'm going to move forward if there are no other comments, but I think we take note of your comment. Definitely, we want the building control officers, the inspectors, the building examiners to be more effective and efficient in dealing with the applications that are submitted by the profession. And to that end, we're engaging all municipalities because we want this to change, because this has serious impact on the sustainability of the profession. We can't allow this to happen, unattended.
I have to come in here one more time, Advocate, sorry.
Okay.
We have a present situation in the Tukeni municipality that there is no system that is working for approval of plans. They've practiced with one system, they've practiced with the second, and it's gone over 9 months now. Plans are in there and nobody has looked at it. There's a serious obligation by the council and SECAP to look into this problem, because the practice at the moment, the professionals, I heard the call from Nadine Naidu earlier on, who's had the same cry that the municipalities are not interested. They're getting a fat salary and stuff the professionals. This is unacceptable. SACAP has to include them in the code of conduct, not via an MOU.
All right. No, thank you, my comrade. I'm going to move on then and allow others to also come in and make inputs. Mr. Pierre, are you still there?
Yeah, I'm here.
All right. I'm giving you now an opportunity to you now.
I just wanted to ask a question regarding work being done on risk. I've been approached by various clients who are property developers who are working on projects where feasibility is a very important issue. And the idea that architects can only be paid once the project is a feasible entity. I just wanted to just get some clarity on something like that and what your guidance on that would be.
I think it's a difficult one because SACAP does not have any regulation when coming to the issue of this risk work. So it's difficult for me to answer that question, you know, but I've heard that it is presenting a big challenge because you work on risk, you know, and you work and sometimes this project never materializes, and then you'd have wasted hours and hours and days and months working on something that you're not getting paid on, you know. So it's something that I think the profession need to look into and find a way forward in terms of trying to resolve it, you know. I know that in the legal profession we do have something like that, but there the lawyer simply takes the work, knowing that when the work is complete, the client will be able to get the money and be able to pay. You know, for example, it normally happens a lot in the road accident fund cases where, you know, the lawyer is sure that the client might not have money now, but if the case is taken now and you run with the case and then road accident fund pays, then you're able to take your fees from that. But this is one is different. The way the profession approaches risk work is quite different. And I think it's something that needs to be explored. And perhaps we could actually even develop regulations to guide the clients there who like using this risk thing to appoint or to use professionals. It's something that needs to be considered fully. And I'll be taking it up with the council. I know that the investigating committee chair, Mrs. Pepeta Daki, has also spoken about this issue, and she wanted to be in the code of conduct. But I think we didn't explore the matter any further. Maybe more time is needed for us to explore the matter and come up with regulations to try and guide the public and the clients out there.
Because I feel like we've got an issue that clients approach half a dozen architects and have the opinion, this can only go ahead and we can only pay you once it's feasible, and then they've got half a dozen designs that they can choose from, and then choose not to pay the other architects who've spent a lot of time and effort putting into their project. And I think it's incredibly fair for them to expect us to do that, and from a lot of individuals, I think it's expected. You know, I mean, I finished my master's in the end of 2018, and I got registered middle of last year, and I'm new in the industry, and I'm dealing with clients, and I'm not as clued up as some other architects, and I feel like us youngsters get taken advantage of in the worst possible way.
Yeah, okay. No, I think you raise a very valid point, and I can promise you that this matter will be explored further. Perhaps regulations might have to be put in place to try and deal with the issue.
Advocate, at the risk of running your seminar, webinar, can I come in on that point?
Okay, you can come in, yes.
I think that way we have to look at this is illegal competitions between professionals. And a professional could ask a prospective client, how many other architects are looking at it? If there's more than me, I'm not looking at the work, because that actually constitutes, in terms of SIA regulations, an illegal competition. And I think that even when we look at Department Public Works, that they should become aware of the fact that some of these processes are actually illegal competitions in terms of the professional regulations.
Okay. Point is well taken, sir. If there are no further comments on this issue, I'm going to move to the next hand.
Can I would like to add something.
Oh, okay. Go ahead. Yes.
Yeah, on that point, I think there was a big misunderstanding or interpretation in how this was implemented in South Africa. For example, in the UK, how working the risk in the architectural profession was that a developer would approach, say, 3 or 4 firms. They would then all go through stages, say 1 to 3 to get to, or 1 to 2 to get to the end of a conceptual design. They would be paid for that. The risk was that none of them was guaranteed that the project would go further. So you don't stand a guarantee that you will have full remuneration for the 6 stages or the stages that would be following. In South Africa, unfortunately, it has been implemented where the developers think that you have to work for free and until they get to a solution or that they feel is beneficial to them. So I think when we look at how we can legislate this is put into place where fundamentally what they're asking the architects to do is to go through stages 1, 2, and sometimes stages 3. So you should still be paid for that work. And if there might be some discount, one can discuss that. But that is what needs to be put into place. And understanding is that, yeah, it's like going to a doctor and willing to pay the doctor only if the medicine works. It unfortunately doesn't work like that.
Thank you, Theo. You made that point very clear.
Yeah, I think that point is well taken as well. I'm going to move on. The next hand that I see in front of me here, I know the hands can move up sometimes. I apologize if I take a wrong hand, but I have got Joseph van Hasten here.
Yes, thank you very much for the opportunity we have been afforded. These are issues that Nadine mentioned to you that quite often we are in the Eastern Cape, so the Metro and also the Kouga municipality have found that we comply to deemed to satisfy rules of SANS 10-400, and then they don't apply it or they don't respect the rules, and they want you to appoint engineers for even putting up a vibratite wall, foundation design for a vibratite wall. And I found that just by the surface of it, that the people that's been appointed in those posts for as building inspectors, they don't know the sound spec or the deemed to satisfy rule. And this has been a problem we found here in the Metro, and even that some of the rules that are applying to like geysers, gas geysers, that some of the building inspectors have their own preferences as far as that concerned. I feel that SACAP has got to address the municipality to comply to the national standards. That's the standards we are working accordingly, and not imply that they use their own preferences as applicable to the specific situations. That's it.
Okay. No, thank you for that comment, Joseph. The comment is well noted. I think we will definitely have to take these issues further and see how we can get the municipalities to comply with the NBR to make sure that they don't hamper the work of our professionals in any negative way whatsoever. May I move on if there are no other comments with regard to the points that are raised by Joseph? All right, I'm moving to the next hand, which is it Nina? Nina Hood, are you still there?
Yes, can you hear me?
We can hear you,
Advocate?
thank you very much, yes.
Thank you very much to everyone for this outstanding opportunity for all of us. I would like to refer to 4.1, where the registered person has certain responsibilities in connection with the agreement between the RP and the client. I have found in my practicing as a architect, excuse me, that the agreement set out, and forgive me if I seem to be the only one in this circumstance, that the various institutes that various registered professionals are registered with, the fee agreement, the written agreement can be often overwhelming for a client. And so many of my peers, as practicing registered persons, prepare a interpretation. Forgive me, I use that word very loosely, but sort of a shortened version, so to speak, of the fee agreement or the written agreement. There are many aspects that one has to include in that agreement, and that directly relates to our conduct, expectations, and various other obligations. Excuse me. Now, the client often is overwhelmed. My last fee agreement, I had to explain in quite a lot of detail to the client, who was, it was their first time building, and they, the process as the service we render to our clients is very complex. And we have mentioned that in this presentation and discussion today. There is a lot of scope for failure and misinterpretations by your client. This often leads to a dispute, as everyone has come to realize. I would like to ask, how can one better this situation? In a way, sorry, I know this is a very loosely asked question, but it really is the immediate forefront, upfront discussion between, the professional registered person, whichever category you fall in, and the client. It is a huge issue. For me, I don't know how to address this, and I'm sure I am not the only one, and I know that I'm not the only one sitting in this seat today with this massive predicament, whether you are a sole entity or a large practice. This is often where it all goes horribly wrong right from the start.
Okay.
Thank you very much.
Thank you very much for that question. I'm going to open the floor to everyone else here, so that we see then how do we deal with the situation. How do we advise?
How do we better this
How
dilemma?
do we better this dilemma? Correct, yes.
Advocate Feduli, Trainer again.
Yes.
The agreement that my colleague is referring to is called a letter of appointment, which can have an abbreviated form of the contract, while also referring to the actual contract as a reference. In my personal view, in my 40 years of experience, there is absolutely nothing that prohibits a professional from asking for a deposit, which confirms the agreement, and with no deposit, no work needs to be done.
Well, that's correct. Yes, no, I would agree with that. Yes. Any other comment from the legal team? What is your view?
Thank you so much, Advocate. What we have noticed, and it's quite, how can I say it? It's quite challenging for architects or professionals in general to enter into agreements using maybe our terms of appointment agreement that we have on our website, or the SIRE agreement that they have on their website as well. But then what we are trying to say is that you can enter into an agreement. It's not an obligation that you must use ours or the SIRE ones, but as long as the terms of appointment which are on the code of conduct are met. So you can formulate your own and then include our clauses that the rule or the code of conduct stipulates. And thereafter you can minimize yours, and it can be much smaller, because looking at a 15-page document that you need to sign the first home builder, it becomes, okay, what am I entering myself, what am I putting myself into, you understand? So if you can make it at least more understandable, because we are trying to put it out there for people that do not have the services to appoint lawyers or whatever legal professional to help them draft. So if you can draft your own agreement which complies with the Rule 4, then you can do that. But if you can't, that's why SAIA has published theirs to say, no, if you can't, or if you don't have, you can use ours. And that's what we did, like the same thing as you find on the JBCC agreement, you understand? So we would suggest that if you can't use ours, or if you can't use size, you can formulate yours, and then it can be compliant with the rules that we can use. Thank you.
Thank you for this. If I may, so in essence, one must actually try their utmost to utilize and make use of CIA and SACAP and JBCC appointments or agreements between yourself as the registered person, professional person, and the client. It is advised. You're saying that it is advised. I've just found that I have done that in the past, and my clients have actually been so overwhelmed. I have followed up with them and they've run a mile, so to speak, and I haven't heard from them, despite me being as polite as I can in following up. They'd rather go with somebody else who has given them a 2-page fee agreement. However, when things do go wrong, and in our profession there is so much scope for things to go wrong, that I find that now I've given my client a 2-page. In fact, I've actually got a case right now where I've got an agreement with a client. They did not feel comfortable using my 7-page fee proposal. So they went, I simplified it, and I guess I am the fool for this. But I'm sure I'm not the only one that's been in this predicament. I minimized made it short, and unfortunately I've shot myself in the foot, because it hasn't worked out well, and I'm in this predicament, and I feel that I can't approach SACAP right now because I haven't used one of the can you see? So I'm actually exposing myself right now. I'm putting my hand up and saying, listen guys, I'm in this predicament. I'm sure I'm not the only one, and this is what I'm finding is happening over and over again, and it's impinging on my code of conduct.
No, we hear you. Thank you for those comments. I just hope that you can be able to explain to some of your clients that the terms of appointment protect them and because clearly there you have to set out the scope of your services. Client must clearly give you what the scope. The issue of the fees, the issue of professional indemnity insurance, those things are there to protect both of you. So I think if clients can have that understanding that really this 5-page document is there to protect the client and yourself, then that would be great. And I think maybe we as SACAP must also start more campaigns, and try to educate the public about the importance of this document. Or the issue of an agreement. What does it mean, and why must it be signed? So that at least we, there's not much effort from your side to try and convince them to sign the document, because it's really the document is there to protect them. So I think the SR manager is here as well. We need to be able to start doing online campaigns, to send it out to all our public forum to say, look, an agreement must not scare you. This agreement is there to protect you, so that everything that you expect from the professional is written down. Everything that is expected from you in terms of paying fees, doing that, but the professional is there, so that dispute can be resolved easily. So that if any professional negligence, there's also professional indemnity insurance, then you are protected as a client. So maybe we must start selling this 4.1, to the public out there more often, and I think we'll start working on that. Maybe it will assist us going forward, so that clients are excited when you say, here's an agreement, it's a 5-page, sign it. It is there to protect you. It's there to protect me. Everything's in writing.
I thank you greatly, Advocate, and I thank you on behalf of all registered professionals of every category that have found themselves in this very difficult predicament. Thank you for your efforts.
All right. No, thank you very much. No, you'll see some action from Art very soon. There'll be some action out there. All right. If there are no, further comments or questions on the issue that has been raised, then I'm moving forward then to the next hand here. Who's next here? Let's see. Is it
Leon? Leon.
Oh, Leon. Okay, Leon is next. Leon?
Yes. Good afternoon. How are you?
Good afternoon. We are fine. We are fine. Thank you. Thank you for attending.
Thanks. I just want to add to Mr. Nel and Geo Klute. Currently, with the municipal fees and stuff, we're currently sitting with a big confusion, if I can put it that way. You do have architects and draftsmen and actually people just getting out of school submitting drawings at council and getting approved, some of them in 1 day, some of them in 9 months. Depends how big the envelope is in the council. And I'm going to say it open and clearly, you can look me up. It's actually happening currently. I'm sitting with about 4 to 5 cases where it's happening currently. But on the other side, I'm also sitting with architects that's charging between 25 Rand a square and others that's charging 680 Rand a square to do mock-ups and drawings. So how do I take it further from there? Because if you go according to your national fee scale, there's no normal person that's going to pay 120,000 Rand for 1.2 million house, if I can put it that way. They're going to go for the cheapest person possible, rather hit their head twice, get another architect going to charge them 45,000, and that's the way they're going to handle it. And currently, this is a big problem, and I can almost vouch for almost every architect out there that this is a big problem. I'm sitting with a big firm. Everybody knowing to run a firm, you've got professional architects, everybody needs fees to be paid. On the other side, you need to also pay for your drafting programs, Autodesk, and so forth. That's 45,000 Rand per license. So the cost just keeps on building up. So to run a company, just a medium size, you're looking at 350 a year just from being a member at SIA and SACA. And on the other side, you can't get your clients in because they're not willing to pay 35,000 just for something small. So is there any other way that we can get to a fee conclusion, doing, say, for standard say house personnel or people doing houses in small scale, and then for public works? Public works, it works 100%. You can do your normal fee and you say, give it 20% discount and do your tender according to that. But currently, there is no set thing that can actually be affordable for the normal person out there. Nobody will pay 120,000 just to have a small house. I think just as well get something off the street. He's got one certificate under his name, but he's allowed to submit. And currently, it's a nightmare at the council. I'm standing in a queue for 2.5 hours just submitting drawings. And then on the other side, the guys are coming in from left, right, and center, and nobody's registered. I looked them up. There's 3 firms registered in our area, and there's 60, 70 people submitting, and I only have 1 certificate, and they're all working from home. So what is the whole conclusion? I don't know, Mr. Nal, maybe you got some feedback from you from the legal side, but I don't know how to handle this. Why do I need to certify and get registered company numbers from SIA and SACA if everybody can just work from home, submit as they want, charge as they want, and nobody can actually take them to court or anything like that? As soon as I say start submitting, because I did take it further, I did send SIA and SACA an email, and they just said, provide us with proof. No, go to the council and ask them for a list of submissions and so forth, you'll not come right. That's one question. If I can say it like that. The second one, I want to find out the land use schedule for councils, the LUMs, if you want to say it like that, land use schedule. Is there any way that SACA or SIA is also part of making decisions on how they decide what rules and regulations are they currently going with? why I'm asking this question is currently we're sitting with a problem where the council is making up fees and changing fees in a monthly basis. So if the client asks you, what is your monthly, let's say, give me a fee proposal with submission fees included. There's no way that they can actually be worked out, because the time we need to submit drawings to that point and give them the council submission fee, the price has changed again. And then the client says, but you already gave me this price a month ago, but due to the council and lack of people looking at the drawings and so forth, the price went up again. So it's difficult in that way. And that's why I'm with Nadine, Naidu, and Joe Kuta, and everybody that mentioning council problem. I think currently, it's 85% of people on the seminar that's struggling with the council problems at the moment. I'm sitting with projects from March last year, and at the moment, I think the total is of 85 projects lying dead still. People can't get SPLUMA certificates, people can't get transfers done, banks cancelling the loan approvals and so forth due to the fact that council are not operating. Even though you go to the drawing department, it's fire departments, it's city planning, it's all the other departments that just closed due to COVID and then back opening in 2 weeks' time and nobody's getting back to it. And on the other side, they're just charging more fees. So your client wants to find out if they paid a certain amount of money, why do they need to wait 6-7 months because they already declined, the bank declined the offers and so forth. The seller who already signed on the house is not been set up due to the new SPLUMA Act, and it's a nightmare. I don't know if there's any feedback that I can get from you. Thank you.
All right. Okay. Thank you. Thank you for the 2 questions. I'm going to allow anyone who's able to answer the questions an opportunity to do so. Who's able to answer the questions?
Advocate Crainanel again, GIFA.
All right. Please go ahead.
There is a misperception that high fees are illegal. I'm very well aware of a very well-known Cape Town firm that asks 20% for any work they do. So we mustn't assume that people are not prepared to pay for services. I recently did a fee lecture at GIFA for our members. And one of the things is that you cannot compete with unreasonable people. So if you find that you get entangled in that kind of competition with somebody that's unqualified or not registered or another category, we prefer to look at all the professional categories, not as higher or lower categories, but as auxiliary professionals to one another, like pilots. Some of us have Boeing license and some of us have Cessna licenses, but we all serve the same public. But it's interesting to see that you have a choice. And in my free lecture, I said to our members, you have to decide on your lifestyle that you require, your income that you need to generate, and then compete to people that are on the same level as you. So, the idea that you have to compete, we also believe that it's a way to filter work to our to our auxiliary professions that you might not be interested in doing, but don't compete with unreasonable people.
Okay. Thank you very much for that, Mr. Nell.
Advocate, may I come in?
Advocate?
Yes, finish up and then Mr. Ramlal will come in.
Just before Comrade Ray comes in, if anybody, the person asking the question wants to discuss this with me outside this forum, you're more than welcome to let him have my contact details, and we can go into that. Also, just to raise again the importance of belonging to a voluntary association where you can go for advice. The other thing I thought about the letter of appointment that was discussed earlier, it may be very useful for a registered professional that is drawing up their own letter of appointment, their shortened version of a contract, to have that approved by SACAP. So if somebody could forward their own letter of appointment to you saying, this is what I intend to use, is it okay with SACAP?
which is fine with us. I think we'll appreciate
Thank you,
that.
Mr. Null.
Okay.
Yes, that's,
Leon,
sorry
before you
for,
come in,
jumping in.
Leon, before you come in, I think Ray was up. Let's give Ray a chance, and then you can come and respond.
Thank you, Advocate. Thank you very much. Just 3 quick points. I think we need to compliment SECAB on providing a SECAB contract to all VAs and professionals. I personally use the SECAB contract on every major or minor project I do, and clients actually have a lot of confidence when I produce this contract for them to sign. And I'm telling you, it works best in society, since it became available to professionals. The second point is I agree with Kerry now, agreed in a sense that we're saying that when you have this contract, signing the contract, if no work being done, no pay, a 20% deposit in today's society is reasonable to ask the public before you start any project, because in this competitive society, things change drastically. And I agree with Kerry now, where he says at least a depositable, suitable for commencing at work goes on very well. And just lastly, I think, I also hear the cries of other professionals. As I mentioned earlier, Advocate, that, we seem to have a code of conduct of 3-way. I'm pleading to you as SECAB to basically, the only way the council is going to start approving plans to take our names, up and up and build the economy is if you as SECAB not allow them to sign an MOU, but get them involved in the code of conduct. That is the problem, because they are regular monthly paid staff who you and I are paying their fees. Yet they would not approve a plan. And as a couple of speakers earlier said, I'm standing in the queue for 2.5 hours and somebody's on the other side has gone in and out, invisibly like a ghost. That's unacceptable. SECAB needs to look at this very seriously, because, as Kerry Nell says, by accepting a deposit, but you still got to perform in order to get a contract. I want to compliment you as SECAB. You've got a lovely contract. I enjoy using it, big or small, but I want to tell you, at the end of the day, the contract is one thing. It's just a piece of paper. You can light it with match and it's gone, and people disappear. At the same time, if SECAB does not come in and deal with government bodies, we as professionals will be heading for more and more disciplinary action through SECAB. Thank you.
Thank you very much for that, Comrade Ray. I think, Leon, you wanted to do a follow-up on the comments from Mr. Cranon.
Yes, thank you. Also, thanks, Ray, for that one. I'll also have a look at that and see if it's similar to my appointment letters, clearly stating all the services we will provide and also with what level we will do it. I think the main reason that I'm also asking is there a way that we can get SAI involved with SACAB at the council, whether you sign your MOU to make sure that the guys who's actually registered are truly registered. I know for a fact that nobody's looking at that stuff at council. There's a lot of forms that needs to be submitted. Nobody's looking at it. I know Johannesburg, Tswani, all those guys on the ball, everything is sorted. If you know you submit, you know where to pay, you know where to submit everything. But currently we're sitting with a problem in Mpumalanga where it's not the same story. We're sitting with smaller towns and places like that, and I can guarantee you nobody even knows who SACAB is, but they're submitting drawings. And that puts you in a difficult problematic area if you've got wild farms and bigger projects. For instance, I'm busy with a 6-story building, looking at 50 million at least. And the client just said, well, I'm not paying more than 230,000 Rand for complete drawings whatsoever. If you can't help me, I'll get somebody from another place. Now, how are you supposed to make your money back on a project like this? Yeah, but there's somebody that will actually do it for that money. And also we need to pay bills. So you need to go lower. And in the end, you're cutting all your income off. It's difficult. I've got staff to pay. I've got rent to pay, we've got license and certificate, all the stuff, like you said. And I don't know if there's a certain area that we can actually open and report people like this and say, well, guys, this is what you're looking at. Everybody always goes for the cheapest option. But isn't there a way or clause we can keep them to it? That you can say, well, fine, you're working on a 50 million project, so your fees are at least this amount, but you can't do a 50 million project for 220,000. It's ridiculous. And this will be overdone for, say, a year and a half, 2-year project. So that's why I need advice on that side. I'm being through it. I'm not sure. It doesn't fall under clause 4.1. I just need advice on that. Then I'm done. Thank you.
Okay. No, thank you for that. I think
can I come in?
Oh, okay. So, you can come in, yes.
Okay. I think what Leon has now mentioned, that really paints a picture of the scale of fee cutting that's in the industry. It's not cutting it by 30 or 40%. That is literally the amount of cutting that, and that is why it's such a drastic point that needs to be addressed. And I don't have a proposal at the moment how we can address it, but I truly think that that is one of the main important points that needs to be addressed. And then I just want to touch on what Mr. Nel was saying earlier, where we need to look at a proposal of taking a fee for work that's being done before we pretty much start with a project. But I think if we actually look at our contracts, that is what stage 1 is. And it's just unfortunately that most people don't even upfront charge for stage 1 when they're doing the work. They're just doing it on good faith, and then if nothing happens afterwards, they lose out on the amount of work and the money that they should have earned. So there is actually already a stage that makes account for that work, going to site, looking at the title deed, all those things. That is stage 1. That is the work that you do in stage 1, and that's a fee that you should be getting for it.
All right. Thank you very much. I think just to also add some few comments with regard to the issue of the municipalities. So what we've been doing, for example, let's take KZN. We've been working together with SAIA KZN to deal with the issues at eThekwini municipality. And that collaboration seemed to be bearing results because we were able to put pressure. The same applies to if you take Free State. I mean, SAIA Free State as well has been working with SACAP to deal with the challenges that are faced by professionals there at Mangaung municipality. You know, from time to time as well, the SAIA Pretoria one as well, we've been working with them together to deal with the issues happening at the Tshwane municipality. We've been, when it comes to Joburg, we've not yet worked closely with GIFA to deal with some of the issues that are faced at the city of Johannesburg. But I think the sooner we get close together and work together with all the VAs, you know, to confront all the issues that our professionals are facing at all municipalities, the better. And we're also engaging with SALGA because we want to bring them to this issue as well, because SALGA is responsible for all the municipalities. We want them to be able to assist us with all the issues that RPs are facing daily in these municipalities. So we really want to encourage all the VAs to come to the party and let's work together to try and resolve some of these issues. And then the second issue then is the issue of the fee guideline. You know, and it's a big issue. And I think our code of conduct is broad enough to deal with some of the professionals who are just, you know, undercutting, you know, to unsustainable levels. I mean, if you're going to undercut or price below your cost by 40%, 50%, 60%, that's not sustainable. And it's not possible that you are going to provide a quality service. Most of those professionals who do that, most of the projects they're involved in never turn out right. There's always issues of poor workmanship, you know, quality of work, quality of materials. So I'm urging all professionals who have those kind of issues to really bring the matter forth to SACAP. If you know that there's a professional who's really ridiculously pricing below cost, please bring the matter forth to SACAP so that we can look into the matter, because that matter is going to affect the entire profession. It's not going to affect that professional alone. Because once one professional undercuts, you know, other clients think that it's okay. you know, to expect other professionals to undercut. So this must be a joint effort from all of us as a profession to say that we're not going to accept anyone who's going to abuse the profession and want ridiculous discounts. We must be able to fight it ourselves. All right.
Advocate Crainer Nell again.
Yes, Mr. Nell.
I'm very happy to hear about your involvement with SALGA. You may know that I sat on the National Building Regulations Review Board for some years.
Yes.
And there was a very simple appeal process if you didn't get plans approved, where you could go to the NBR review board. That has unfortunately now collapsed with a recent constitutional court case. And we need another appeal body. And I believe SALGA would be the right people to look at.
Yeah.
We've looked at, for instance, the City of Johannesburg Ombudsman, but their scope cannot include for that at the moment, and it should be a higher body. So we believe working with SALGA would be the right way to do. In terms of checking registration, we believe it should be very simple for a local authority to go on the SACAP website and check if a person is currently registered and in good standing. There's really no excuse for them to approve plans where the person isn't registered or not checking the accuracy of the person's representation for that. In terms of risk work and clients that want a lot from a lot of architects or architectural professionals, again, it's important to belong to a VA that we can help you. But there is something called the deferred payment agreement, where you say to the client, okay, I agree with you that I'll do 1 and 3, 1 to 3 or 1 to 4, but you must pay me for that on completion of the work, or when the project becomes feasible. This at least reduces your risk that you're not competing with other professionals while you're doing the risk work. And a deferred payment agreement should be investigated by those people that have those problems. And again, in terms of lower fees, you can't compete with unreasonable people, but it is your duty as a professional to explain to your client why they are at risk. So don't just say no to the work. You can write a nice letter to them saying, we believe that it's not in your interest to appoint people at the rate that you propose. And in order to work at that level, we have to expose you to risk. And we cannot do that as professionals. In terms of people that, parties that are forcing architects to compete with one another in an unreasonable manner, I believe that SACAP should really look at Department Public Works as the first accused, because we've heard of the Eastern Cape where Department Public Works have appointed people at 20% of the published gazetted fee schedule, and that is where collapsed buildings and things originate. So, we have to. The first party that should be educated about this would be Department Public Works.
Thank you very much for those comments, Mr. Nell. We really appreciate that. All comments are really going to be considered, and I think we'll use them going forward to address some of the concerns that have been raised here. This is a recorded webinar, so we will be able to download it and be able to share with those who may need
And then, Advocate, we'd really like to extend a hand to you and thank you for the opportunity. I'm president of GIFA. We'd like to work with you more closely, not only with the City of Johannesburg, but also other local authorities that fall into our jurisdiction, like Ekurhuleni, anybody on the Midrand, etc. I mean, on the West Rand. And we do have a local authority that is performing extremely well, and that is Midvaal. And I wonder if we cannot learn lessons from Midvaal, how they deal with it. I mean, I've submitted work, and within 10 days, I didn't have a letter, but a phone call to say your plans are ready for collection. So how does this small local authority managed to satisfy both clients and professionals in the same way. They are one of the top 10 local authorities in the country.
Okay. Thank you for that, Mr. Nel. Much appreciated. I'm going to take the next hand, which is Africa Mahobe. Africa, are you still with us?
Yes, hello.
Yes, we can hear you. Go ahead.
Thank you, sir. Thank you, Advocate. I believe there is an actual point that a gentleman earlier tried to address. However, I feel it wasn't fully explored. The issue of the local municipalities, local authorities, the people that work within those municipalities. Those people as SACAP, shouldn't you be able to check where those people are actually architectural professionals? Because I believe that if you are a person who is on the front line in terms of the actual front desk of the local authority, dealing with incoming plans for submission to council, you should at least be an architectural professional that is registered with SACAP. And I believe that part of the problem that we are facing right now is that I suspect that a lot of these local authorities do not have such professionals. And part of the reason why I can't remember the gentleman's name, but he brought it up that Rule 1.4 seems to be 3-dimensional and not 4 because of such a reason. That is the question that I wanted to ask. Thank you very much.
Okay. Africa, we thank you for that question. Just to briefly respond, the issue of local municipalities and the plan examiners, building inspectors, and the building control officers is regulated by the NBR Act, as well as the NBR regulations. You'd know that the NBR regulations does provide what are the qualifications of a building control officer, but it does not provide what are the qualifications for a building inspector or a building examiner. But I think if you look at those requirements, the architecture is there, engineering is there, QS is there. So municipalities are able to employ different people in the built environment who can serve in those roles. But what I must report on is that there's been a category of registration that has been created for building control officers. These people who assess and then recommend for the approval of plans. Now they are currently being registered to SACAP. Now that they are registered to SACAP, the code of conduct that we're discussing today is going to be applicable to them. So they will be expected to perform their services, based on the minimum standards that are accepted in the code of conduct. So I think to address your question and Comrade Ramlal's question, we are looking at this issue comprehensively to make sure that we work with the municipalities. As much as the MOU, we look into how we and the local municipalities can make sure that the municipalities, they do their part in terms of making sure that plans are assessed within prescribed timelines, and to make sure that from our side we also give them information for them to be able to work or maybe only accept plans from professionals who are registered. We also have to make that information available for them so that we do away or we prevent people who are not registered from submitting drawings. So I think we will cover the issue that you are raising. Once the registration is complete, the registration is ongoing. As soon as it's complete, and then we'll make sure that also the code of conduct applies to the building control officers as well. So I think that would have addressed that issue going forward.
I thank you. I thank you so much.
Right. No, thank you, sir. Thank you for that. If there are no questions or additions or comments on the issue that Africa and Comrade Ray raised. I'm going to move on to the next hand, and the next hand here is it Catherine? Is it Catherine? I think you have spoken, Catherine. Am I right?
Yeah, you can take Carlos.
No, Carlos Batista. Yeah, Carlos. Yeah, let's take Carlos.
Good morning. Can you hear me?
We can hear you. Good morning, sir.
Man, it was just a comment relating to the fees that's being charged.
Okay.
I think
right.
Leon Viviers also mentioned that there's many projects that come about where clients don't feel they need to pay exorbitant amounts of money for plans. In my opinion, you will always find that somebody will charge you less than the next person. There will always be a better price. I think as a way forward, and it's potentially a good suggestion, that SACCP needs to regulate how fees are presented. There's the guideline that SACCP currently has, but there's no minimum fee that is charged. For example, if somebody comes along and says, listen, I'm going to charge this guy 100 Rand a square meter, as an example, somebody else will come along and say, but I can do that job just as long as I get the job for 10 Rand a square meter. That is always going to be the case. And I have found that there are RPs that are charging a lot less than what is actually prescribed. And I think therein lies the secret, is that SACCP needs to say, listen, okay, you cannot charge less than this and you cannot charge more than this. I think you guys need to maybe consider something like that. Thank you.
Carlos, we thank you for that comment and that suggestion. However, just to emphasize that currently the Architectural Profession Act only allows SACCP to publish guidelines. However, we know that in most African countries, there are prescribed minimum fees. So it seems that SACCP has actually been aligned to mostly the first world countries, and we've neglected to make sure that the fees are regulated. There's a minimum fee that are regulated, but currently that's how things are. So we have to comply with our legislation.
I understand that, Advocate.
We thank you for that.
I understand, but then we will always have the case where people are going to undercut in terms of
undercut. Yes,
always going to be that problem. Then we're never going to get a solution. I'm sorry.
And this is hampering actually the growth of the profession, because you're not getting enough fees, but you're doing work.
Exactly.
Advocate, if I, at the risk of overrunning your webinar again, it's very important for clients to understand what they're paying for. And at GIFA, we've developed the idea that what you are paying for is a mold that you will pour your money into. So it's very important that you buy the best mold available for your product. And the better equipped or the more time the professional has to develop your mold, the more likely the client is to lose money while the project is on site. So we are actually mold producers. You know, we do specifications, we do everything. All of this is to reduce the financial risk of the client. And clients should understand that we are also, in fact, their financial advisors, because we tell them when something is too expensive, when we can do it at a better rate, where we can save money, etc. And I think clients must understand that if they had to invest probably their biggest amount of money that they're likely to invest in their life, whether it's a 10-story building or a single house, that they are buying the best services to produce that. So very often clients believe that the more money they save on the mold that they are going to pour their money into, the more money they have available to spend on the actual building. Now, that is a fallacy that we also need to cure. The better the mold that you buy from your professional, the less money you're likely to lose when you're on site. So it's an educational process as well.
Mr. Now, I'm sorry, but
not
all clients care about the risk, and I don't think it is up to us to teach the clients about that risk. Surely, we cannot be held responsible for the risk that the client is willing to take.
Well, what you can do is you can alert your client to the risk that they're taking by going under the published rate. Because I've had 40 years in the industry, I remember the previous Act, Act 35 of 70, which preceded Act 44 of 2000. And in those years, before there was a competition commission, the fee guidelines actually said from. So you could negotiate up from the fee commission, but doing below that would be considered unprofessional. So it falls on us as professionals to alert our clients to the risk they are running if they run below the published guideline fees.
Right. No, thank you very much. I think let's move on. Let's give us a chance. I'm gonna give Jean Perry an opportunity to come in as well. Jean, are you with us?
I am, thank you. Thanks everyone on the call. This is more just a comment with regards to the council submission frustrations. You know, SACAP and the council themselves tend to be, I don't know, segregated in this whole building plan process just because they're sort of independent bodies of one another, yet we're all falling under the built environment profession. Would it not just be sensible, because most of what I've heard here today relies on human error and not necessarily the professional? So you might have someone at council who's either accepting bribes or just, you know, out of their depth with what it is that they're looking at. So your submission is not necessarily fluid. Would it not be, in this day and age, something very simple to attain, that submission processes, if they were electronic or not, that when submitting something, you cannot submit a plan digitally or in hard copy format without verifying whether or not the person is registered? And I don't mean with a SACAP compliance certificate or a photocopied version of your registration certificate, just a simple electronic database. This person is submitting a plan. Click, click. Are they registered or not? I mean, we're chasing our tails, expecting council to sort of be registered as qualified building inspectors. We're still open to the element of human error, where SACAP's got a registered database of registered professionals, and, you know, a drop-down list or typing in somebody's name to say, yes, this person is registered or not, does not seem out of this world at all. I think it's something SACAP could definitely pick up and probably introduce quite soon, I suppose. And then just a note on the architectural fees. Look, in my experience, I think with most of us, there are clients who you win, and then there's clients who you don't win, and those that you don't win have gone to someone cheaper. But I think what has been missed, and this is really just a comment on it, is that our economy is only as big as it is, where the vast majority of our economy is actually sort of in the, you know, building alterations, very rarely a new house. We've got very few massive infrastructure projects. So the market is not necessarily competitive enough to absorb all the professional architects, as well as moving down the registration line to your professional architectural draftspersons. So we don't have enough architectural businesses employing professional draftsmen to get all the work done. So the competition is almost inevitable. I think the recommendation for a minimum fee could possibly sway that, but it just feels like an argument where we're all asking for our rates to be respected in an economy that can't facilitate those rates. They just can't. I mean, it's a fact. Most of our clients, if I have to go and charge, 250 Rand a square meter for a garage alteration or an addition for it, that person may not pay that money. They will run away to somebody who's going to charge them 15 Rand a square meter. Versus, based on the complexity of the work or the size of the project or the client's budget, it just feels like an argument that has no real answer to it. We're fighting the circumstances of an economy. It's redundant in my point of view. So maybe a minimum fee, yes, but I don't know. I just felt like it was a lot of comment around something that no one-lining regulation is actually going to change based on the nature of how we do business in our country. That's it from me.
All right. Thank you very much. I think you've made valuable points so far as the issue of the website and making sure that we can link up with the municipalities in terms of verification of registration. And I think maybe just to respond to that and say that you are aware of Privy Seal, which is a real-time registration and verification mechanism, which is now a requirement at all local municipalities that if you want to submit, you must be able to produce that seal that shows that today at this particular time you are registered and you are in good standing. And I think that's going to assist a lot. But again, the city of Johannesburg and SECAP have entered into an MOU, and one of the things that we're doing with them is to link our register with the city of Johannesburg, so that anybody who submits an application, these two systems, they speak together. And if you're not registered, you'll be kicked out of the system altogether. So I think that's something good that we're doing there to try and address what you've just raised now. So hence I'm saying that I think I really appreciate those comments so that we can just work together and make sure that we deal with these frustrations. Yep, I'm going to move forward and take Udirile Musimani. Udirile, are you with us?
Yes, I'm here. Can you hear me?
Yes, we can hear you. Please proceed.
Thank you. I would just want to ask, because I have wrote my PPE last year. So I just wanted to ask if I open a company, like as a draftsperson, registered draftsperson, is it possible that when I register a company, I register it as ABC Architectural Studio, or is it not allowed to use like maybe architectural, because like it seems like I'm offending other people with certain qualifications?
Thank you for that question. I'm going to allow the legal team to address that question. Anyone from the legal team, please take on that question from Udirile and try to provide guidance.
If I may assist Udirile, with regard to the word architectural, you can use ABC architectural, but you may not use ABC architect if you are not registered in the category of a professional architect. So because you said that you are a draftsperson, am I correct, Udirile?
Yes, that's correct.
Yes, so you can use, so you are allowed to use the word architectural.
Thank you very much.
All right, thank you very much, Udirile. You may call your practice Udirile architectural drafting. It's still fine. Let me move on then to the next hand. If there are no further comments, I'm gonna call. I'm not sure whether Catherine. Did you speak, Catherine?
No, I didn't. I just had a quick question.
All right, go ahead.
A lot of my clients, or just about all of my clients, want to use the Proxa contract. What's SACAP's? And they get all the consultants to fill that in, and mostly we're not the project manager on the job, which is the architect. What is your feeling about Proxa, and yeah, from SACAP's point of view, will we get into trouble if we use it? What's and my clients all say it's a lot easier. They're just going with Proxa. They're not even if I roll out the architectural contract, they don't even, they just want to laugh at us and say, no, please take that thing away.
Okay, no, thank you for the question. Let me allow the legal team as well to address that question as well. Anyone from the legal team?
Thank you, advocates. The Proxa agreement has been used a couple of times in matters that I've investigated, and I've seen that it does cover most of the things, and if not all of the things that we wanted to see in agreements. It's a very big actually complaint that I have currently now, where they utilize the proxy agreements and we found that everything complies. So I think it's just important with any agreement that you use, as we're saying, that we're not strict so that you have to use a specific agreement, but with any agreement that you use, that it does comply with all the requirements in terms of Rule 4.1 and whatnot, and that it's understandable for both parties. Thank you.
Okay, thank you. That's I'm happy to hear that. Thank you.
All right, thank you very much. Thank you,
Advocate, can I
that.
come in here?
Yes, come in, Comrade Ramlal.
Thank you, Advocate. Just on the point of the contract, I just also want to mention, I've been around in this business for 45 years, and I want to say that I've learned a lot. And the SECAP contract, basically, that I use, as I mentioned earlier, it depends how you present yourself, to your client. And I found clients are excited to sign a contract, whether it's Proxa or whether it's SECAP. The important thing is when they sign a contract, they know that they are in safe hands. So I think it's very important that I mention that whilst I've been around for a long time, it's also very important as the day, the market is very competitive, but it's very strictly looking at a contract. It depends totally on the professional, how you present yourself and how you present your submission to clients. And I think that's important. Thank you, Advocate.
Thank you very much for that, Comrade Ramlal. I'm going to move on to the next hand that I see. I think it's Lawrence Ngeke. Lawrence, are you with us? Lawrence, can you hear us? All right, it seems that Lawrence cannot hear us at the moment. We'll come back to him. Let me go to Helen.
Hello?
Hello, yeah, we can hear you. Is that Lawrence?
Yes, I'm with Lawrence here. I work with Lawrence. Lawrence is the
all right. Please go ahead, yes.
Yes, I have the privilege to attend this workshop today. I just want to ask, we work very closely with the Midvaal municipality and Joburg City and Fuleni. And as a professional stated earlier that Midvaal is very efficient. Indeed it is, but I just want to know they've got a new rule, a dolomite issue where clients need to submit an individual dolomite review of their site. This is proving a problem to many of our clients because what they find is that the area with which they're living in already has a dolomite issue, but the municipality is still insisting on individual dolomite reports, which can be very costly for our clients. I just want to know if SECAP is aware of this, and we also found that other municipalities are not strict on the issue. I just want to know if SECAP is aware of this, and how can we help our clients out in terms of being able to cover those costs where they have to do an individual dolomite issue report. Sorry.
Thank you very much for that question, Lawrence. I think all municipalities have got their own regulations, So, and from time to time, they would expect all professionals to comply. And if they require that each and every client to produce that certificate, or that assessment, we have to comply because maybe we don't know the severity of the dolomite in that particular space where you want to build something. So maybe they are justified to request that. But from our side, we have not heard anything about this issue. But if professionals feel that SECAP must be able to take up this issue, I think professionals can request SECAP to engage with the municipality. We will definitely engage with them and raise any issue just to make sure that we make things more easy for professionals in terms of submitting their applications. So you can drop me an email anytime, and then we're prepared to take this thing up with the municipality and see how we can make things easy.
Advocate Crainer Nell again.
All right, Mr. Nell, go ahead.
In terms of professional services, it's very important that the client understand that they also have duties under agreements. They can't just mess around. They also have to do what they have to do. In terms of the SIA client architect agreement, and I'm not sure about your own, it is very clear that two things have to be delivered to the professional by the client. One is a survey of the site. I'm still shocked to see how many people produce plans that have no survey or contours on them, because that will cost the client a fortune when they get on site. So the professional is allowed to insist on two things: survey of the property with a recent survey, not a 20-year-old one, that shows all the buildings, neighbors, etc., that the professional calls for. And the second is a geotechnical report. So the clients must understand that just like a doctor is not going to operate without an X-ray, we actually cannot produce work without these two pieces of information.
Thank you very much for that. I think that's mouthful there, Mr. Nell. I'm moving to the next hand here. I think I've got, is it David? Eric? David, are you with us?
It should be Helen.
Oh, it's Helen, all right.
And Lufoko, then David last.
Okay. Let's give an opportunity to Helen. Helen, you are muted. If you can unmute and then be able to speak.
Can you hear me?
We can hear you. Can hear you. Go ahead.
Good afternoon, and thank you for this. It's been a great help. I get a few frustrations. I'm a technologist, and as much as I present myself as such, the clients get confused. And I think so. If SACEP could help us by informing the layperson out there what the various areas are, it would be a great help, because I find often it's difficult. You do express yourself as a technologist, and then you get referred to as an architect, and it's town planners who do that as well, professional town planners. And I've even had architects that I've worked with who have introduced me to clients as an architect. So for the technologist, it's very difficult, because when it works to the advantage, we are an architect, and then when it's a disadvantage, we're a technologist. That also applies to fees, because I've been caught both ways in providing fees to a client which are as per the fee proposals that you guys have got, where architects have said that we can't charge the same fee as a degreed architect. And then other times where you will charge a lower fee, and then the architects will say, no, but you can't do that. So I think we need clarity and help, and just to educate education for all, that we all on the same page. Because I find even in terms of the contract, if by some means we can be on the same page, it will go a long way to reducing the confusion, because I think the confusion arises only because the communication is not there. I mean, I still don't know as a technologist what fee I charge.
No, thank you very much for those valuable points, Helen. I think we should be able to undertake media campaigns, public campaigns, to educate the public about the different categories of registration. It's very important, and also coupled with that, we must make sure that the public also understand the competencies for each category of registration. The public must know what a professional architect can do, what a professional senior architectural technologist can do, and so forth. And I think that in that way, it will be able to assist the public as well to understand the difference between these categories of registration. But also,
Advocate, can I come
the issue of the fees. I think that the fees are not determined by category of registration. The fees are determined by the work that you have to do. And the fees determined between a client and a professional. So you should be able to look at costs and tell a client, regardless whether you're a draft person, whether you're a technologist or senior technologist or architect, you must be able to say to a client, these are my costs of providing a service to you. And these are the fees that I'm charging you. So in that way, you are more factual. Your fees are not a thumbs up. They're based on your time of providing a service, and it's factual. You can prove it that no, this is what cost me for me to provide a service to you. So I think you need to explain that to the client so that the fees have nothing to do with my category registration, but the fees has to do with the service I'm providing to you and what it costs me to provide a service to you. That message must come out loud and clear to all the clients. But I think our stakeholder relations manager is here in Tokozo. I think he has taken notes of all the comments we've made around educating the public, about the categories, educating the public about the issues of fees and all these things so that they are able to know what to expect from the profession. Definitely is one of the actions that is going to consider going forward. Comrade Kamal, you wanted to add something?
No,
Thank
that's
you.
fine. Thank you.
thank
I
you.
think you've answered me.
All right.
I would like to add something.
Thank you, Advocate. Thank you. I just want to go to earlier comment by Crane now. I think I agree with him fully that
Yeah. Okay, go ahead. I'm listening, Comrade Ramla. You are muted, comrade. You are muted.
I think I'm going on. Sorry. Thank you. Okay. Every professional, before they do any project, should definitely go out and get a full survey, requesting the clients to get full survey and contours, including a geotech report, because Comrade Nell is right. Nobody can do a job, any plans without these, supporting documents that would give accurate, planning details and good architecture in areas. Thank you.
Thank you very much for that comment, Comrade Ramlal. Any other comment on the issue raised by Helen?
Yes, I would like to.
All right, go ahead.
Okay. I think, and I wanted to actually raise it earlier as well, there seems to be a misunderstanding in the industry that a senior draftsperson necessarily needs to be paid less than an architect, professional architect. I think that should be part of the education. If they are both working within their allowed scope of work, so for instance, if they're both doing a double-story house, there's no reason why the senior professional technologists should be earning less. If they can secure a client for the same fee as the architect, why not? So I think the issue around fees, is what another person earlier pointed to, the starting point would be to look at bringing back again the minimum fee scales. And that would be going a great length to addressing it. And when we try to educate our clients and the public, it's not as a matter of our time that's going to be spent, because often if I'm very proficient in design, I can actually design very quickly, but there's things like what other people have mentioned as well, is all your operational costs, your backup costs, your archive that you have to be running, and if you've got staff and all of those issues that comes on top of my time, which is actually costing me my business to run. And that is what clients often don't see and easily to neglect to acknowledge.
Thank you for that, for those comments. Comments are well accepted. I'm going to move on then to the next professional who's here. I think it's Luvuko. Luvuko?
Yes, Advocate. Can you hear me?
Yes, go ahead. We can hear you loud and clear.
Thank you, Advocate. Well, I just want to start by saying thank you to SACAP for all the initiatives that they're coming through with and speaking to the profession and the professionals. there is progress, and we are really appreciative of the way SACAP is engaging us as the professionals. My name is Luvugo, as you said. I'm representing CYBID, and it's just two things that I want to put forward. Firstly, in terms of the code of conduct, we did submit some comments to SACAP, which were very extensive, and I can't go over them here, but I'd just like to request if perhaps you can give us some feedback on those comments. I hear you're going to be publishing the code of conduct. We'd just like to know whether those comments have been considered, what your thoughts on our comments were, and whether you'll be making any changes or what your reasons are not for doing that. We'd like to just get some feedback, generally speaking. And then just to go to the issue of the fees, I think the fee issue sort of overlaps with the code of conduct a lot. It has to do with indemnity sometimes, it has to do with the contract and all those sort of things. And we should appreciate, and I think some of us do appreciate that there's different streams of economy in South Africa. There's one market at the very low end, is the one at the high end. And trying to marry those two, which are so wide apart, I think is the general problem that we're facing, you know. And I know SACAP is working on this, and so it's not an easy it's not an easy problem, but it's something that needs to be really looked at, because there are people who are charging very low, and some people have their reasons because they're in the township, etc. And there are people who are undercutting on fees that we all know should be, let's say, at a certain threshold, you understand? And so we need to look at those things line by line, you know. We can't put them all into one box. And so it's just a very difficult problem that comes from our past, and that we just need to look at closely. And I'm aware that SACAP is working on that. And as CYBID, we'd really like to continue working with SACAP to try and resolve these issues, and not to push aside some of the harder questions, but to actually really look at them closely and come to, you know, not everybody's going to be happy, but at least try, you know, to come to some sort of understanding with each other. Thank you, Advocate. All the best to SACAP and everyone on this forum. Thanks.
Thank you very much, Luvugo. I've just noted that I think you are a member of a task team that is working on the fee guidelines. And I take note of the comment that you have made about the fees. I'm sure these issues will be explored further at the task team that you're part of. But I think just to come on the first point that you raised about the code of conduct, yes, indeed, I think we were about to publish the code of conduct. All comments that we received from all the VAs and all RPs have been duly considered by the investigating committee. Some comments were accepted and some comments were not accepted, and for various reasons. And indeed, what we'll do is we will write back to CYBID and be able to, and other VAs, of course, to say that these comments were accepted, these comments were not, these suggestions or additions were accepted and were not accepted, and for whatever reason. And then we'll also confirm which ones have been included in the code of conduct. Selina, I think she's here, the legal secretariat responsible for running this project on the code of conduct, she's here. I think she's working on that, in fact, because I think that was a directive from the investigating committee that we need to be able to respond to all those who made submissions. So we will respond in due course, Luvugo.
Thank you, Advocate. Really appreciate that.
All right. Mr. Nell, you want to follow up?
Yes, I wanted a question. I believe that the current fee guidelines, the 2020 version, doesn't actually differentiate between category of profession, because there's only one line, there's only one graph. Is that correct?
Yes. No, the fee guidelines do not differentiate between categories of registration.
Yes.
They focus on the work that you are doing.
I'm raising that because there was a previous question about why a senior technologist or a technologist cannot ask the same as an architect. And I'm just pointing out that there's no differentiation in the SACAP fee guidelines at the moment.
Yes, correct.
The architects are not very happy about that because we've spent more money on getting our qualifications, and that doesn't make it very viable sometimes. But we do have to allow for other professions. It may be surprising to my other colleagues to learn that about 3 years ago, before Act 44 2000, SIA did a survey whether non-architects should be allowed into SIA. And I was one of the people to say that I know many draftspeople that do better work than some architects. So, you know, we do consider our other professionals.
Okay. Is it your suggestion that the fee guideline should be crafted in a manner that takes into consideration the category of registration? Is that your suggestion?
I'm saying that in the current version that hasn't been looked up very closely, but one of the hidden costs of the profession that's been raised previously is not overheads only. It's not only your number of staff, software is very expensive, etc. But we also have to look at recouping the fees or the money like student loans and cost of education. So an architect has typically spent 5 or 6 years in obtaining that qualification, and the current fee guidelines don't actually make it that easy for them if they're competing with other professionals to recoup that money. But that's something I think should be investigated in the future.
Well, definitely. I take it that you are a member of the task team, so at least you'll be able to raise those issues when the task team meet again.
I'm not a member of the task team.
You are not?
No.
Oh, so you've probably delegated somebody else to be in that task team?
That's correct.
Oh, all right, Malita. No, that's fine. I don't know, Ramlal, your hand is up. Is it a comment on the previous suggestions and comments and questions, or is it something new?
I just, Comrade Advocate, thank you very much. I think I actually compliment, Comrade Nell, because yes, there is many professionals who are not architects do provide better service to the public. And I want to compliment him for bringing that up, because undoubtedly, we need this economy to grow, and no insult to any professional. I think it's important that you find that a big man like Comrade Nell also acknowledges that and accommodates the society. And I want to say thank you to Comrade Nell. Thank you.
All right, thank you very much. Let me then move to the next hand. I think is it Dino?
And the next hand, it's David, then Dinel.
Oh, David, Eric?
Hi, can you hear me?
We can hear you, yes.
Yes, hi. I just wanted to ask you a specific question. In the area that I work in, there are cases where some professionals allow others to use their registration numbers to submit drawings, often unqualified or unregistered people. Does the Code of Conduct cover this? And are those professionals breaking the Code of Conduct or not?
Thank you for the question. Let me allow the legal team then to handle that question for us. Anyone from the legal team to answer the question? It doesn't seem that the team is here, so let me go ahead and address that question. So basically, it is unlawful for anyone to allow a person who's not registered to use their registration number. And if you've got any information about such activities or such conduct, please email us so that we can start investigating that conduct. We know we do receive a lot of complaints about professionals who even rent their own registration numbers, and they don't see anything wrong with it. So it's improper conduct, and please share the information with us so that we can investigate and be able to discipline professionals who do that.
Okay, and then, but it's not specifically referred to in the code of conduct. So perhaps what we need to do is make people aware of the fact that that actually is something they shouldn't be doing.
All right, definitely. I think we will issue a communication to RPs just to notify them about it.
Okay, thank you very much, Advocate.
Thank you very much. Let's move then to Dino.
Unmute, there we go. Can you hear me now?
We can hear you, sir. Please go ahead.
Wonderful, thank you. Far too many comments, so I'm just going to limit it to 2 from my side.
Okay.
I think part of the problem we're having in South Africa is the copious amounts of confusion regarding the multiple registration categories. And my personal view is that SECAB should find a course of accelerating the conversion of the different registration categories so that within a short space of time, we arrive at either professional architect or draftsperson, and that is all, you know. And I think if that can be accelerated, even with the offer of proper certified curriculum and a proper certified qualification from an institution. I understand the RPL exists. The RPL has got certain flaws. It sometimes works, sometimes doesn't. But the RPL at the end of the day does not support the professional's position with an actual tertiary education qualification. And so some sort of forced, and I mean, I'm putting the pressure on myself. This won't affect any professional architects because you guys are already there, but I'm a senior technologist. So I'm actually suggesting to put the pressure on people like myself to upgrade on purpose within a limited space of time. And that would resolve a huge amount of confusion within our country very quickly. That's just a comment. My question is regarding all these private housing estates where the estate guidelines within the constitution and within the architectural guidelines specifically limit the professionals that are allowed to be appointed within their estate to professional architects only. Even though, okay, the identification of works is in the mix at the moment and not quite empowered, but previously when the IDOW was empowered, these unfair competition practices were still in place, limiting people like myself or senior technologists, etc., to not be able to compete within those environments, even though our qualifications legitimately allow us to. So I'd like to know from SECAB if anything is being done to address that unfair competition in the South African economy. Thank you.
All right, Dino, thank you for that question. Maybe let me first start with a comment on the categories of registration and say that there has been some discussion in the council, you know, about the number of categories of registration, and there's a strong view that at some point we may not need so many categories of registration. So that discussion is evolving, and I think when the council is ready to speak to the profession about it, they will do so. But your comments are taken and definitely will be conveyed to the council. The second issue about the estate, we are fully aware about the challenges that are faced by professionals that are not professional architects around the country. You know, in all these estates, we've been engaging with SIAT a lot, together with the Competition Commission, try and address this issue, because our view is that if a professional is competent to do work within an estate, that professional should not be prevented from doing the work. If you do prevent such professional, then your conduct is exclusionary and it's anti-competitive. And these issues have been raised directly with the Competition Commission, and they are working on a plan to try and deal with these issues. In fact, we had a meeting with the Competition Commission last week, and one of the agenda items was the issue of the estates. And the Commission is very clear that any conduct which is exclusionary with no basis whatsoever, that conduct is anti-competitive and it must be dealt with. So they are busy from their side, getting ready to see how they can handle the matter. But from our side, as SECAP, together with SEAD, we've been really engaging a lot of these states. We've had meetings with a lot of them. And in the agenda, we've always stressed that we've got an IDOW, which is clear in terms of who is competent to perform what work. And that is the only document that can be used to exclude anyone to perform work in the estate. Without that document, on what basis are you saying that a senior technologist cannot perform work in the estate? On what basis are you saying that a professional like textile technologist cannot perform this kind of work in the estate? There's no basis whatsoever. And that is not acceptable. So, and that's the message we've been spreading to them. And all of them have said to us, all right, no, it's fine. Send us the draft IDOW, because we've made it clear to them that the IDOW is not yet ready at this point in time. And we've sent them the draft IDOW, and we've said to them, this is a document that you can use to make lawful legal decisions to exclude a person. And as soon as the IDOW is now published and gazetted, it is going to be law now. And now we'll be able to send it to all the estates and say, this is a document that you can say to a professional architectural draftsperson that, look, the house that this homeowner wants you to design, you are not competent to design it. And this is the basis of it. And in that way, then you have a basis to exclude a professional. But without that, there's no basis. So I think we will continue to engage on these matters until.
Can I just give you some finer advice on that, Advocate?
Yes, let me finish answering the question of this, and then you can also comment on that. But I think I'm just trying to at least give him enough information for him to understand that what is the stand of SECAP on this matter and how SECAP is doing to address the issue together with the Competence Commission. Dino, are you still with me?
Yes, thank you. Just muted because of the background noise.
All right. No, thank you very much. Mr. Nell, you want to comment?
I have full commiserations with non-architects that are facing these problems.
Yeah.
The challenge legally is, of course, that many of these are private estates, and a single individual may be the person that is in charge of the estate until 51% of the estate is sold up and the homeowners association is formed. The one person can be in charge of that. I have looked into this very carefully, and I've taken guidance from the South African Human Rights Commission, for instance, where religious groups are excluded from certain land in the country, or people because of their gender identity is excluded from wedding venues and whatever. And it's interesting to follow their cases that have been decided on this, because unless an estate is a public entity, it would be very difficult to force them to do anything, and they would be quite at liberty to prescribe whatever they want. When somebody actually buys in an estate, they typically buy into the rules and regulations of the estate at the point of sale. So if somebody is unhappy with that, they don't have to buy in that estate. But it's a complicated matter. I just refer you to the South African Human Rights Commissions and decisions they have made, because it seems to be more developed under their jurisdiction than in many other areas that we're looking at.
Well, thank you for that, Mr. Nell. But just to give guidance that in perhaps your comments would have been correct in the previous dispensation before we had a constitution in this country. Now, in this country, we've got a constitution of 1996. That constitution applies, we normally say, horizontally and vertically. Now, vertically, it means that the constitution applies between every individual in the state. When I say horizontally, it means that it applies between private persons. Now, you cannot do anything that is contrary to the constitution and think that it's a private matter. It is not a private matter. It is regulated under the constitution. The constitution is very clear that anyone is entitled to be in any profession, provided it's regulated by law. So there are regulations that have been created by SACAP to address issues affecting the profession. IWW is going to address all those issues. Whether you're in a private land or you're in a public space, you have to comply with the laws of this country. So our message to all the estates is that no one must be excluded unfairly simply because the estate is owned by some private individual. When people buy into these estates, they are investing their private money, and they're entitled to choose a service provider whom they deem fit and appropriate to provide a service. So it's unconstitutional for anyone to prevent a homeowner, somebody who's paid money, to choose a professional who is competent to perform a service. So SACAP is working together with the Competition Commission to address these issues, and we will address these issues head on, so that we want to make sure that anyone who's competent to perform any service is allowed to perform that service, as long as a homeowner or a client says, I want to work with you, because a consumer as well has a choice. And remember, we've got an act, it's called Consumer Protection Act. A consumer is entitled to choose a service provider that he or she wants to use for any service. But what we're emphasizing is that the estate have a right to say that consumer that you are choosing, you as a homeowner, must be competent to be able to provide us that service, so that we're able to keep the standard in the estate. That is a fair rule. So we will be working together with the Commission to address these issues. So I want to assure Dino that these issues are going to be addressed. And we are working together with SIAT. SIAT has been really pushing from their side as well. We will get on the bottom of these issues. Thank you very much. Let me move on then to the next hand. I think it's, is it Gray? Is it Gray Chatbon?
Yes, it is. You just need to unmute himself.
Yes, just unmute and be able to speak.
Hello, I think that was a mistake. I didn't put my hand up.
Oh, is it? All right. Not a problem. All right, then, colleagues, we seem to have addressed all the questions arising from the webinar on the Code of Conduct. Perhaps as a parting shot, is there any other last comment that you want to make before we can close the webinar? I'm going to allow anyone who wants to make a comment, a suggestion on how to improve, how to do things better. Please make that comment before we close.
There's a hand from is Abby and Catherine.
Yes, let them speak.
Hello?
Yes,
hello,
please.
can you guys hear me?
Yes, we can hear you.
Good afternoon to you guys. My name is AB and I'm a registered architect.
Okay.
Can you hear me? Sorry.
We can hear you, AB. Can hear you.
I seem to have audio issues here on my side. what I wanted to add is one of the things that I've hear everybody communicating about is the issues of. Sorry guys, I'm getting feedback on my side. My apologies for that.
We can hear you though. We can hear you very clear though.
Okay, can you hear the feedback on your side?
No.
Well, I can't hear any feedback, but I can hear you. You are very clear.
Okay, all right. Let me rather continue so I don't waste everybody's time. One of the other things about our as architects, technologists, and so forth, is that I tend to think of aligning ourselves, our profession, with other industries such as legal profession, accounting profession. When we get customers coming to us to discuss services that we provide, when customers go to a legal professional, for instance, to go and ask for legal representation, one of the things that they don't discuss, lawyers don't actually have discounts in their profession. We in the architectural profession, we have discounts, sometimes ridiculous amounts of discounts. So what I would like to see, I hear everybody actually wanting to escalate and perhaps remedy the development and growth of other lower professions in the industry to get to an architectural level. I don't have an issue with that, but I think it needs to be calculated carefully in terms of how it is actually executed and how people are then promoted to the level of architect, if you will. It's like in the legal profession, you would not, as an attorney, go and represent someone in high court. So you'd need an advocate to go and actually represent those issues in a high court, but an attorney can address some issues at the magistrate level.
Yeah.
So what I'm asking in my comment is based on the fact that we need to start looking at aligning our industry similarly to other industries in the country like law and accounting. And in terms of how we actually get ourselves to that level where, you know, everybody who comes to us for the service that we can provide, and they don't come to us that they can actually ask for a discount of 40 or 60%.
All right.
So that is basically what I wanted to add. Thank you, Mr. Chairman.
No, thank you very much for those comments. I really appreciate it. We really need to align ourselves to other professions as well, so that we're able to get ahead. I don't know whether are there still more hands here. Munisi,
It's just me. It's just me, Catherine.
Yes,
Catherine, yes.
Just something quick. If I had to give you some advice, it would be really lovely. This is just a wish.
Okay.
If you had an app, and on your app you had, we could download the app, and then all the registered professionals would pop up on the app, and it would be something that you could communicate quickly with your professionals. Everybody signs in, updates their details. Everybody's going onto their phones a lot, so it's something that's I don't know, I just thought it'd be quite nice. You know, somebody's at the council office, you know, there's council desk, when you submit a plan, they can even quickly look up there, like bang, and oh yes, that person's registered, or no, sorry, you're not on the list. Just to make it easier for us and for you. I just thought maybe.
Thank you for that, Catherine. Our IT manager is here, Munetsi. I'm sure you'll.
Okay. Thanks, everybody. Thank you for a wonderful talk. I really enjoyed it.
All right. In the absence of any other hand, I'm going then to
leader, there is Griff.
Oh, there's another hand.
Good afternoon.
Good afternoon. Good afternoon, Mr. Vessels.
I must say thank you very much. This has been a wonderful seminar, a webinar. Just perhaps one contribution I can make based on the calculation of fees in the 5 different categories. I did develop a spreadsheet whereby you calculate the value of the project, which then automatically calculates all the different fees for the different breakdown. I have sent it to SACAP before. I just have had no reply from them. But it's a tool that can be used by everybody, and it's freeware.
If you can just please email that to me, Mr.
Okay.
Vest, I really appreciate. My email address is toto.fiduli@sakapsa.com.
Can I just write that down quickly? Just give me a moment.
TOTO.
TOTO.
Dot.
Yes.
The same name there, FIDULI.
FIDULI. Yes.
@sakapsa.com.
Okay, fine. I'll send it off to
Please.
you. And it's quite a tool.
Right.
It's freeware, you know, because invariably, one of the first questions that you get asked is, you know, what are your fees? And if you do a calculation on, or you just do an estimated project value, it kicks out the answers immediately, and you explain to your client, you know, this is what you're being charged, and you don't have to apply, you know, the 5 different categories. But it's a very handy tool.
Okay. All right.
And really, it was a very nice webinar. Thank you very much.
No, much appreciated. All right, Munezi, do you still have more hands?
Oh yes, I've got one. Jason Simon. Then okay.
All right, go ahead, Johnson.
It's Joanne. It's Joanne Simon.
Joanne. Sorry.
Yes, I just wanted to double check, and if maybe there could be a resolution to this. Not so long ago, I got a call from a municipality in Limpopo saying my certificate submitted some drawings which I never did. So it was hard for me to track as to who used my certificate unlawfully. So I was wondering, aren't we allowed to watermark our certificates? Maybe we write the name of the project that we're submitting so that people don't have the liberty to copy the certificate when you've handed them.
All right. Thank you for that. But I think, Joanne, previous seal, I thought it has addressed that problem, because with previous seal, the certificate is real time, and you are the only one who can download your certificate and submit to the municipality. So no one will have access to it. Anybody who goes to the municipality with it, it means you'd have given them permission. So.
Oh no, actually, it was like 2 weeks ago where I got a call. Pardon?
Do you have access to previous seal?
Yes, I do, but still my certificate managed to be used elsewhere.
The old certificate?
Yes, they managed to use the old certificate. So the municipality wasn't querying my certificate, it was querying the whatever's been submitted, that maybe something is wrong and needs to be. Yes, but not the certificate and when it was produced.
Which municipality is this one?
Mogalakwena.
Oh, Mogalakwena.
Yes.
All right. No, we'll be in touch with the municipality just to advise them that previous seal is the best one. I mean, you are the only one who can give access to that certificate through a profile. So if they request that, then they shouldn't have issues. But we will write to them and advise them that they must only accept certificate that are real time from previous seal.
Oh, thank you so much.
All right.
Yes.
All right. All right, thank you very much. I see that there's few more hands.
Yeah, it's only one hand, Chair. Advocate, can I come in?
Okay. Go ahead, Comrade Ray.
Advocate, thank you very much. I just want to say on behalf of FACE and all the VAs and professionals that have sat in this webinar, excellent presentation from SACAP and very good contribution. Thank you very much. It's been a long day. I think what's important, just for me to close up and say, whilst I say thank you, just one question. Would SACAP be providing every professional a copy of this code of conduct before it is advertised on the day you choose to advertise? Thank you.
Thank you very much, Comrade Ray, for those those complimentary words. We appreciate that. Definitely, all RPs would have access to the code of conduct, especially the new one, just to make sure that everybody has it. And we intend to even print booklets, you know, that will have the act, the code of conduct, and the rules of inquiry, so that as we're doing our work, we've got a pocket booklet where you can refer, you know, when dealing with your client. So we will be rolling out that that process very soon.
Thank you, Advocate.
All right. No, thank you very much. No, thank you very much to everyone who made time to attend the first series of the Code of Conduct webinar. We're going to have more of these webinars because we want to make sure that all professionals understand the Code of Conduct. And we know that when we do that, we will avoid many complaints that we receive daily at SECAP. So we are going to have more series of webinars. We will, in fact, collaborate with the VAs as well. We work together to move the profession forward. You'll be notified on the date of the next webinar. Perhaps in the next webinar we can even break down the rules. You know, rule, for example, if you take rule 1, it's quite a long rule. We can take rule 1 and run through it and even give examples of what are the issues that normally come up there, so that when you leave the webinar, you fully appreciate rule 1 and what is expected from you. And then the next webinar, we run through the entire rule 3 and 4 and so forth. So we'll see how we plan around it, but we intend to have more of this engagement with the profession to try and improve our understanding of the legislation as well as the code of conduct. I thank you very much. The president is not here to say the last words, so I'm going to say the last words on his behalf. I thank you. Have a good afternoon.